Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. This is the voice of Cheryl, and I bring to you a true story. Now, all of the facts of the story I don't have, but the story is true nonetheless. You see, one thing I know about facts, they change rapidly at times. Greetings, so Alicia. Good to see you. I want to talk about the use immunity that was given to Woody to testify in this case. You see, I have a theory, and then, a lot of people call it conspiracy, call it what you like. I call it common sense, wisdom, and living for 65 years. That's what I call it, but you can call it what you like. But something just doesn't add up. Number one, most people, oh, that is so sweet. Let me please acknowledge you and all of your love. I guess I should have started this off issuing my condolences to Kenneth Copeland, Woody. I saw stories on YouTube and the news in Atlanta that he lost a friend, an associate, whatever he feel about him today. But he's no longer with us. And then I know there's people going around harassing people, harassing me. That's what people do when they can't stop your joy, when they can't stop what's meant for you. They try to confuse you and confine your mind and take you to a place that you don't want to be. And you don't have to be, because the choice is yours. So you don't have to choose to go there. And, some people just, she needs to quit playing them songs. But I love to sing, and they really help me. So I want to just dedicate this song to all of us that can't shake people. Or I should say the people can't shake us because of the impressions that we leave in people's lives. They can't get enough. And once they've messed up, they realize it. But it's no turning back. So I want to dedicate this song to myself, so Alicia, Maria, Asatar, Shug, people in the world that are going through things, Woody, and Jeffrey Williams, known as Young Thug, and all the young men that sit in that courtroom, and their attorneys who are fighting against a powerful weapon a weapon of mass destruction. L.A. Pink called them political gangbangers. I join her in that title. So I'm going to just dedicate this at the beginning. No weapon formed against me shall prosper. It won't work. No weapon formed against me shall prosper. It won't work. You see, Cheryl will do what she said she will do. She will stand by her word and see it through. No weapon formed against me shall prosper. It won't work. There just ain't one weapon, no. You see, I'm the weapon. And I do what I say I'm going to do. And so where I say my name, you say your name. Because you're the weapon. You make it happen. Or you allow it to happen. Or you stop it from happening. Sometimes you don't even know how you do it. But it gets done. And that's all that matters. Self-love, self-preservation. That's what it's all about. Which takes me back to the political gangbangers. And the way I see things about this case. You know, I just wondered, why did they offer this young man immunity? Because, you know, most time from looking at TV, and that's all I really know is TV. Hey, Asatar. When I look at TV, most people are begging for immunity, but they rarely get it. In this situation, from what I believe happened, it takes me back to the Friday morning when the young man was going to testify and his attorney showed up. The prosecutor was very upset, and the judge was too, even though he played it off a little better than the prosecutor. And actually, they were not going to even acknowledge the attorney, but they got an email that Thursday evening letting the prosecution know that you've contacted my client, knowing that he has representation. And so he won't be talking to you guys. He's wanting to take the fifth. Okay. I'm imagining those were the words in the email because I don't know what was in the email that he sent to them. I just know the conversation they had that Friday morning in court, and that's what he was explaining to the judge. Not only that, he explained to the judge that these people knew that he represented this young man, and they knew it back from 2021. But, of course, they pretended they didn't know. In my mind, I believe that they knew he was going on vacation that Monday because, as I showed y'all the other day in my video, I think it was the one with the judge, and I may need to show y'all that calendar again, the judge's calendar, and how many days they've worked and how many days they have not worked out of 99 days. It's amazing. And how many half days they've worked. It's really ridiculous, to be real honest about it. Let's see if I have that. Well, I can pull that up right quick. It's really sad. This is the longest running case in the history of Georgia. And a lot of people want to know why. Why does Bonnie Willis keep going after all of these RICO cases? Well, I have a theory, again, it's my opinion and the way my mind operates. And what my mind tells me after I heard when Ashley Merchant discovered her illicit affair with the special prosecutor that she hired, when she actually allowed her lover to become the special prosecutor to prosecute President Trump. And this man has never prosecuted one of these felons that they have running around Atlanta. You know, they have a problem, a serious problem, in my opinion. But when I listen to the Senate committee hear about the monies that they give to the judiciary, which are the judges, they gave them, between the judges, the clerk, the sheriff, and the DA, they all split $75 million. This is outside of their budgets. So that tells me that it's a lot of washaterian clothes going on. We call them washaterians. Some people call them wash houses. But the law called it money laundering. And it's a lot going on. Because these people get an itemized budget. And then once they get the money, that they tell these people, we need these things, these things. We need expert witnesses. We need more lawyers, more prosecutors. We need, I don't know what the court needs, but whatever they need. The sheriff needs more officers for the jailhouse. The clerk, I'm sure, need more clerks. But when they get the money, they say they're constitutional officers, and so they can spend it the way they want, not the way that they went to the commissioners to ask for the money. There are no checks and balances, so nobody knows how the money is spent. They just know every year they come back needing the same stuff. And so Ashley asked for all of these people that the DA hired, and for some reason they don't keep those records, and they have refused to give her the records, so now they're involved in a lawsuit. And they said she named the wrong party, and the judge gave her 20 days to correct that. So that lawsuit is going forward. But what I want to just tell y'all about this case, that's the longest case in history of RICO, with 28 defendants. So much so they had to break them into two groups, and then one or two guys were severed altogether. But it says day 100, which will be tomorrow. The Young Thug trial is this Monday. And we got this, and let me just show y'all, because I showed it before. I want to show it again. Because we should be concerned about this stuff. I'm not lying. We as a people should be concerned. What happens in one state eventually happens in your state, if this is not your state. And we need to be concerned about this. We want to know why vote. Locally, why vote? Because those are the people that are like these people that sit in your courtrooms, that sit in the DA's office, that sits in the sheriff's seat, that works in the jail. They're over those people. And you want to know what those people stand for and who they are. Because everybody that say that they're righteous is not righteous. It's not what you say that shows how righteous you are. It's what you do. It's your actions. Now this says day 100 of the Young Thug trial is this Monday. Breakdown of Judge Glanville's court schedule over the past 7 months starting November 27th. That's how long they've been in the courtroom. 2023. 63 full days, 34 half days, 3 days canceled after judge took the bench, 59 days off, excluding weekends. Now tell me who gets to work a work schedule such as that. And they have caused, I'm told, I have not done like Ashley and requested a FOIA. $47 million. $47 million. That's a figure. And now, this comes from Thugger Daily. He's on X, and I just recently got on X. And he does an outstanding job with doing pretty much hourly, and sometimes 2 and 3 hours. But he's real good at keeping us abreast of information that he finds on the Young Thug trial. So the breakdown of Judge Glanville's court schedule over the past 7 months. And here, this is the calendar. And I wanted to show y'all this is because attorneys have to calendar their days. And when they're going to take vacations, they have to submit a calendar. And they have to do this for the court's sake so that, you know, the judges won't schedule them to be in their court and they have, you know, vacation time. So I believe that the prosecutors got a hold to Mr. Melnick, who represented him in this case. In this situation, he represented him. And they knew that. Miss Love knew it, and I believe Miss Hilton knew it too. I just don't believe she didn't. And I believe that in the way she testified before the judge. But be that as it may, they scheduled him to testify. I believe well, first they didn't know his lawyer was going to get involved until they found out the Thursday evening before he was going to testify that Friday. And then when the attorney showed up with him that Friday morning, that's when he was arrested because he told them he wanted to take the fifth. And I think he misunderstood the judge when the judge was explaining to him that he's got to tell them. And he said, I could tell them what I want to tell them. And he said, yes. So I think he believed that that meant that he could say that I plead the fifth. But he ended up being locked up. That was really strange. But if you read up on these judges, like the judge I just did the other day, who's going to be hearing his recusal motion, they said that she was assigned it, but she may not get to hear it because they're not supposed to be on the same level. It's supposed to be another judge. But what was really amazing to me, is the fact that this man, Glanville, he seemed to know everything and pretend that he doesn't know. When they left that Friday, he told Mr. Melnick that he'll call his person in before the jury and get him, because Mr. Melnick told him he's going to plead the fifth. That's what he want to plead. And he said, okay, well, we'll just see what happens Monday. But I found a clip, and I need y'all to hear this clip and tell me what your opinion is. I found a clip well, I looked at the video, but this clip I thought was very important. I want y'all to listen to what Miss Love says in its totality, and listen toward the end because that's the most important part. I'm going to let it play a couple of times so you all can hear what she said. Well, we're going to take the calendar down. But before I take the calendar down, let me just show y'all the days. I put that up there just so you can see his calendar. So I believe they knew his calendar, Mr. Melnick's calendar. But this is how the days go. These are the full days, these are the half days, and these are the days off. Now, this is the longest running trial, the most expensive. They are very unorganized to me. Seems like they don't know what they're doing or what they're talking about, but they really do. It's just not working. November, they worked 4 days. December, 3 full days, 2 half days, 16 off days. January, 9 full days, 3 half days, 11 off days. February, 9 full days, 7 half days, 5 days off. And that's excluding the weekends now. March, 7 full days, 5 half days, 10 off days. April, 11 full days, 7 half days, 4 days off. May, 9 full days, 5 half days, and 9 off days. And the month of June, 11 full days, 5 half days, and 4 off days. So this is really pathetic for this to be the longest running and the most expensive trial. So now we're going to go over here to what I want y'all to hear. So what she's telling the judge, and she said this in open court. This was in open court, okay? And that was that Friday evening. She said, Your Honor, the state has a matter that we'd like to take up ex parte with you. Now remember, the defense said on Monday when they came in and was waiting for 2 hours, they didn't know what was going on. And they found out after lunch that the judge, the prosecutor, the sworn-in witness, a couple of the sheriffs, a couple of investigators from the DA's office, and the court reporter were all in an ex parte meeting, which you can't do that and talk about substantive information germane to the case without all parties being present. That's a constitutional right. It's not a privilege. It's a right. So here she's asking the judge for an ex parte. So then my question becomes, then were there 2 ex parte meetings? And I would venture to say that it was. Now I could be wrong, but I'm going to tell you, I doubt it. I could be very wrong. I've been wrong before. but I doubt it. And the reason I doubt it is because they had one that Monday morning, and I think that's when they called the young man and his attorney in. I believe. Now, I could be wrong. And it's okay. But I'm going to stick with my wrong because that's what I believe. Okay? So I believe they had the ex parte that Friday evening, and they had all conversation that they needed to have. Now, before that Friday evening, when they had the first ex parte meeting, that Friday morning, I truly believe that's when they gave him immunity. You know, because before they got that email from his attorney, he wasn't under an immunity. If he was, it wasn't signed by the judge. We knew nothing of him having immunity. They never said that. It wasn't until his attorney sent them an email that Thursday to let them know that he has representation that they came that Friday morning before court, and the judge signed off on the use immunity. And use immunity is very important. You know, I tell you all the time, words are very important. And nothing is going to change for us as a people until we start changing for ourselves. And, you know, none of us can practice law for someone else. None of us can give legal advice for someone else. But you can certainly present yourself, your case, your situation. And we don't know all of the legalese and all of the decorum of a courtroom. But one thing we do have, and this is the information age, if you go to any court's website, it's going to tell you the rules of the court. If you go and visit their courtroom, you'll get to feel the feel of the judge. You can navigate what you need to. And if you feel overwhelmed or can't do it, then you get someone that's licensed and that's not only licensed to practice, but have a history of winning. You don't just want to get a lawyer just because you need a lawyer. You want to get a lawyer that can maneuver through the system. And most of the time, if you get one of those, they're going to cost a pretty penny. And if you don't know anything about this system, you would think that they're overcharging, but I guarantee you they're not. This stuff is very, very, very time consuming. But the good thing for them is they went to school to learn how to research and how to look at or view the law, because what's going to actually dictate the law is the interpretation of the judge. And if he doesn't set the precedents, he's going to go by past case law where the precedent has already been set. And he's going to pretty much go along with his fellows. So that's how that works. And you have the opportunity to do the same thing. The only thing you don't have opportunity to do is go to Westlaw, which is where the most current law is. But if you have a law library, you call your law library and see if they have free access for the public. You may get an hour or 2 hours to go through Westlaw. And that's where you find the most recent case law. You can find a lot of things on YouTube, on the internet, Google, on the Edge, and other search engines. But some things in law you're not going to find publicly. That's by design, in my opinion. So I thought that was strange. And then the young lady that stood in for him, His attorney said he couldn't be there. He had plans, he had vacation, and it had been there for a while. And so he said he would get somebody to stand in for him. All she was supposed to do was just to show up and be there while he said, I plead the fifth. And they were going to take him back in custody. Now, I don't know what happened and if she was involved that Friday evening. They did have to give her name and information. The judge wanted that information, but he didn't ask her to file an appearance paper. I thought that was strange, because when you go to court, there is a document that you have to fill out to show that you are going to appear. You see, everything there is a process, and no matter what nobody says, it may be different verbiage in different states, but the actual statutes are federal, and then they tailor to your state. And mostly all states, they don't maybe read the same on some things, but on some things they're not going to change. That's why I always try to encourage you to go and look in your computer, go find your rules of civil procedure for your state constitution, the rules of evidence, and the rules for criminal procedure. And then also then go to the federal level and do the same with the federal and put them in your favorites. And whenever you get a free time, free moment, just read them. You may not never need them for yourself, but you never know the way things are going today. There was this beautiful young lady who just graduated high school, Asiatic, and she was in a Challenger or a Charger, and the police stopped her, and the lady said, this is the wrong car. But they had her to get out of her car with her hands up in the air, and all of their weapons were drawn on her. Have changed her life forever. So it's happening to our daughters. It's happening to us as seniors and seasoned individuals. So we just got to start learning how to protect ourselves. Or get in the water with the sharks and hope you don't get bit. Greetings, Phyllis. But as I was saying about Miss Bumpus, now one thing she said, and this puzzles me, because she was trying to tell the judge that she was fired before he ever started testifying. So then my mind goes back to the meeting they had that morning. Was she fired before they even had the meeting? And was she actually really representing him? Because the judge didn't ask her to do an appearance form, but he had her to do a withdrawal. And that gave him 10 days to change his mind. I never heard of anybody on the witness stand firing their lawyer while they're on the witness stand and being in the courtroom without representation. And they say, well, it doesn't matter because you have use immunity. You know, rarely do you hear the prosecution just say immunity. They'll say use immunity. They're saying use immunity for a reason. So all of this to me was just a game to get two birds with one stone. In my opinion, they want Young Thug and they want him bad. Why? Because he has millions. He doesn't have he's had a history in his youth, but he doesn't have a criminal felony record. He has weapons. Well, he's a licensed weapons collector. He can afford weapons. He can purchase weapons. It is not illegal to do in this country. That's why we have the Second Amendment, the right to bear arms. And there are many of Americans that have weapons collections. Many. So it's not a sin or a crime. Okay, my TV just came on. I thought it was off. So, what we have to know is there is a system in place. And, we used to always talk about massa. Well, no, we got to talk about, like I said, the new Jim Crow. Yeah. Jerome and Janita. You can call them whatever you want to call them. But they're going to look more like you than they do anybody. Part of that is the system that's in place. The other part is greed. Because we all have a job. And those people make way more money than we do. Well, I no longer work, but I'm talking about when we are employed. Those companies make millions. We don't go in there taking their stuff. We go in there and do their job and come on home. Now, some people might go in there and take their stuff. But the majority of the people in this world, all they want is just an opportunity. Because they have their own creativity, their own designs, their own desires, and their own mind. And they don't want nobody planning it out for them. They rather do it for themselves. A lot of people make fun of and laugh at people that live on welfare or in Section 8 housing or whatever. Just because you don't have money don't mean you don't know quality and you don't know good and pretty stuff. And don't mean you can't have a desire for those things. They're things. And they're flashed on the television and all over the internet. We're inundated, even on our phones, with ads. The world run on ads. And we're not supposed to want any of that stuff. We're just supposed to look at it and say, ooh, doesn't make sense. But everybody don't want to take somebody else's stuff. And it's unfortunate that the political gangbangers, I call them the boule. And of course, it's not all of nothing. There is a vast majority that's leading us like sheep being led to the slaughter. And we keep buying the story. Talking about we wish it was better. The only way it's going to get better is if you make it better. You better learn different. Because it's a lot we don't know. But she made a statement and she was trying to tell the judge. She even asked him, could she come up to the bench and have a sidebar? Because she didn't want to say it in open court. And he told her no. Why would a judge do that? Unless he knows something we don't know. So I want to play that because I thought that was very interesting. Listen to what she tried to tell the judge. That's so deceptive what he just did and what he just said. Because he made an open court on the record. He said that your attorney already said she wants to withdraw. But she's telling the judge she was fired before he ever started testifying. And the judge is telling her, oh, you didn't put anything in to say you was going to make an appearance for him on Monday, but I'm going to hold you to withdrawing as if she was his attorney. I'm going to hold you to withdraw from his case, and you're going to fill out the form and put it on the record that you wanted to withdraw from his case, not that he fired her. Let's hear that one more time and see if you all get it. And thank everybody for listening, all three of you. And if you would, please hit the like button. I'd greatly appreciate it. And if you feel like it, comment. If not, share the video. Now, doesn't the judge sound disingenuous? He just sounds disingenuous to me. Now, he could be an honest, upright guy, but I do not believe it. And I do not believe that he didn't know it. And I can't even say that her friend, and that's Hilton is her friend. One guy made a video and said that they were sorority sisters. They're not sorority sisters. They do know each other. And then she says that she practiced in Georgia and in Texas. And of course, I showed y'all the other day, she does not practice in Texas because she doesn't have a license. But she says there's some kind of way that they can do something, and that could be true. So I can't honestly say she doesn't practice in Texas, but I can 100% say she doesn't have a license to practice in Texas. And the way they do with the school system, is very hard for me to believe that they would allow you to work under some other state's license when one state doesn't have to honor another state's rules. So that's kind of iffy for me. I don't know what the situation is, and I'm really not interested. I'm really interested in these young men who I believe are getting railroaded. And I'm not saying that the ones that committed the crimes are not guilty of the crimes. I'm not saying that. But the majority of those guys were very caught up in crime, and they changed their lives. And they're not in trouble today. Some of them are in prison because what they've done is they're not getting them for things that were done recently. They're going back to 2015, 2014, 2013. And that's what they're getting them for. which is unbelievable. I just don't believe it. It's really unreal. You really don't see this a lot. The whole world is talking about it now because the judge actually held a sitting attorney representing his client in contempt of court because he found out about an ex parte conversation, one-sided conversation that the judge had with the sworn-in witness in the chamber. And instead of him owning up to what he did, because the law says that he should have told them before or he could have told them immediately after. And instead of him acknowledging, yes, that happened, and let me tell you why, or it didn't have anything to do with you or whatever, or this case, but it was matters that, we can't discuss. He said, who told you? And that's why he held him in contempt, because he wouldn't break his code of ethics and tell him who told. And see, any government job, hey Kelly, any government job, they have exactly, she, that was my point. I hope you don't mind me saying she, but I guess that's she, Shelly. Hi, she. It's good to see you. But yes, that's what I'm saying. Those guys have done their time. They're trying to change their lives. Some of them are incarcerated. One little guy, little Rod, got his sentence overturned. That's a beautiful feeling when they went up on appeal and they realized that they made a mistake. It's a possibility he may get a new trial, or they may allow him to come home. We don't know yet because they have this crazy trial going on now. But I don't know, Kelly, if you and she heard her when she was saying, and when I was trying to explain, I wonder if she was fired that morning when they went in that meeting, because she told the judge before he ever testified she was already fired. But the judge had her to put on record as if she was withdrawing from his case, as if she didn't want to represent him. She was never there to represent him as his attorney. She stood in for the attorney just to make sure he was present when he accepted the fifth and was going to go back to jail. But when they had all of these other conversations and started threatening him with he can stay in jail indefinitely until they finish all of the cases, and we see that debacle. Those guys, a lot of them don't have attorneys, have never met their attorneys. The attorneys don't know what's going on, and the guys are just in limbo, and they all are just locked up because they want everybody to take a plea. And remember, I was doing a series on the trial penalty, which is the plea bargain. It takes away your Sixth Amendment rights to a trial by a jury of your peers. And we don't know how important that really is, but that's very important, to go through the process and don't allow anybody to lord over your life like these people pretend they are, because they're doing some dastardly stuff. But I'm going to just play this so y'all can hear it. If y'all didn't hear it, I don't know if y'all heard it or not. But she's telling the judge that she never was his attorney when he started testifying, because she was already fired. So I'm inclined to believe she was fired when they went in that meeting, or when they talked to him without her, then they told her to fire him. That's just my personal opinion. And anybody feel free to express yours. This is a place where you can express yourself. You see how he put it on her and Mr. Melnick? That's why I know that they waited till they knew that he was going on vacation. Y'all didn't have any sound? Y'all didn't get to hear what she was saying when I played the little tape? It's possible she could have done that. Okay, Kelly, I'm going to try it again because it should have been playing. It's possible, but I'm going to tell you what I believe. It could have been even somebody else, because some of those people probably like Brian Steele. But we'll find out if they ever have that hearing. Let's see what happened that y'all didn't get to hear it. I'm surprised.
Since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, you know, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation. And you and Mr. Melnick and whatever, but you know, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give Mr. One time, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So
were y'all able to hear that? Okay. So see, that leads me to believe that the judge know what he's doing, and he's a part of the state. As Brian Steele said, they've come together and decided to go against them, because if you look at everything that transpired that Friday morning, which I've shared that before in a video, and I'm almost inclined to go back and share it, how Miss Hilton came up there and was telling the judge that maybe, or she believed that he didn't have an attorney. She believed. But when Miss Love came later and she was talking, she knew as a matter of fact that he didn't have an attorney, or he wasn't supposed to be his attorney. So maybe y'all didn't hear me when I said I believe there were 2 ex parte meetings because of what Miss Love said. I don't know if you guys got to see that, but let's see. Miss Love came up on that Friday when he ended up pleading the 5th. At the end, right before court went out, she asked for an ex parte conversation, and she asked for it in the courtroom. So that's why I believe it was 2 ex parte conversations. And the transcript, this is just me, I could be wrong, but with the dirty tactics that they're doing now, that's going to be the transcript they're going to give to the defense. They're going to try to incorporate her and him in that first one because they wasn't in that first one that Friday. You heard it too? Okay, that's good. Let me let y'all hear this because I just want to know. And I bought me an Ethernet little thing and I thought it was working, but I see my thing is still buffering, so I don't know. I'm going to have to let them know that ain't going the way I planned it. But I got me one so that I wouldn't have that problem.
And Your Honor, the state has a matter we need to take up ex parte.
Okay.
And Your Honor, the state has a matter we need to take up ex parte.
Okay.
So everybody heard her say that in court, and they didn't feel nothing was wrong with that because she said that in open court. And so they probably had that Friday evening. What they did know is what was going to happen Monday morning. That's what they did know. Regina said, let me point out that Woody's former lawyer should have filed a formal notification of her being removed as his lawyer by him. Therefore, he could see announced she wanted to withdraw. Yeah, but see, Regina, the way they did it, that man was already out of town. They planned this strategically. Nobody's going to make me believe different. I don't know if y'all saw the beginning where I showed the judge's calendar where they've only worked, 63 days out of 100? No, I think it was less than that because I think they've been off 50-something days. But I just showed it a moment ago. They did this strategically, the state did. Because Miss Love always knew that boy had an attorney. And then we're dealing with young men that, number one, grew up in marginalized neighborhoods, the worst of the worst, they say. Also, they had them in special ed classes, so you know they took medications, and then they just abruptly take you off the medications, and then they started using self-medication. So, and then you're talking about 2013, 14, 15. These people have been planning to do this because it is known in the streets of Atlanta, and I don't live there. This is what's known in their streets, that Fonnie Willis date those type of guys. You know, the ballers, shot callers. And she was with the young man that's no longer with us, Donovan Thomas. So this is a revenge They've been after this young thug for 10 years. They've been trying to get him. And they've tried to use all his people, but they were all in prison and stuff. These guys just came home. And then after they came home, if you look at the charges they have on them, and they don't even have Woody in here, they have him under use immunity. But what I found out about use immunity, all they're talking about, they're not going to do anything to you and they can't do anything to you. They can't do anything to you for what you say, but they still can do something to you. And it does not have to be the feds. It can be the state. They can do something to you for what come out of other testimony. That's what they're not telling. These people are deceptive and they're wrong. And we're watching a modern day, I call it a lynching. We're watching it before our eyes. And nobody is sounding the alarm. It's just like this is normal. And maybe it is normal in courtrooms. That's why a lot of our sons and men are locked up. I'm not saying that people aren't guilty of whatever they're guilty of. But the criminal justice, I call injustice system, is supposed to be fair based on that system. And if you have a jury of your peers, which we rarely get, but if you have a jury of your peers, then they are the most powerful people in the world. Believe it or not, to sit on a jury, you're more powerful than the president, because in that moment in time, you hold the key to somebody's life in your hands. And it's your decision and how you interpret what the judge gave you to interpret is what stands. Nobody can change your mind. You have to change your mind for whatever reason you decide to. But if you believe something to be one way, you can go on to glory knowing that you did the right thing, no matter what the outcome is. She said, but note, Brian referenced a recording. They can play slick, but I think Brian is holding the big joker. I think he is too. I don't think the ex parte happened Friday because Woody had to get back. No, I don't believe that one happened Friday. I believe that the prosecutors had too. Now, I don't think Woody was there, nor Miss Bumpus. I don't think she was there. And then Woody could only go when they tell him to go, because, they control him, so they could have kept him there all day if they wanted to, right back there in the holding tank. So, I don't put nothing past those people. But no, I believe they had 2 ex parte conversations. I believe they had one Friday evening, because she made that announcement. See, if we go by what we thought at first, Brian still can't get up there and say that they didn't have knowledge of the ex parte conversation. Now he can say, we didn't know y'all was going to have it this morning, but he can't say, I didn't know y'all was having one, because she announced that in court Friday evening. So I truly believe they had one Friday evening. What they didn't tell them about was the one Monday morning, when they included Bumpus and Woody. And what I believe is Simone and Bumpus are friends, and I don't know if she told her anything and she would do it because she asked her, or if Woody just got there before Bumpus and they said something to him. Because if you notice, Brian also said that different ones was in the room at different times. So they all were not in this room at the same time. So we don't know really what happened. But when she made that statement in that court saying I was already fired before he testified, is it possible she could have got fired that morning before they went in that meeting, so he really didn't have representation? And then the judge is making her sign a withdrawal, talking about you and Melnick put yourself in this position. No, Judge, the prosecutors did this. He told y'all. The prosecutor knew. Love knew he was his attorney. And they purposely did this. And I showed y'all when he was telling him that he had those non-refundable tickets, how both of them reared back in their seat at the same time, like they were synchrony swimmers. I mean, for real, this is really ridiculous. And I just don't think enough people are crying out about it. I know a lot of people are talking about it, getting a whole lot of subscribers and a whole lot of donations, but they're not talking about these young men's lives and how it can really affect our lives. Even for talking about it, it could affect our lives, because that's how they get us, with intimidation and with fear. And we all pretend we don't fear nobody but the Lord, but that's not always true. And how do you know that? Because you witness too many things that's not right and don't say anything. And sometimes you can just reduce it to writing. You don't have to be on YouTube or in public or marching. You know, you do what you do. But you got to start speaking, because they're doing it to our daughters. They're doing it to us as women. They're doing it to older men. It's got to stop. And the they, we can't say it's the European today, even though we know they're a part of the system. They that's doing it look just like us. The ones that we trust and the ones that we put in office. They all brag about their positions and winning their seat. But when you run unopposed, do you really win a seat? No, you're handed a seat because nobody's going up against you. And I don't know, even in my city, who we're grooming for the next group, that when these people leave office, who are we putting up so that they would be, fit for office? Because you need to know something about what you're talking about. Okay, so she said Woody got booked 139 days before the RICO. After the RICO was filed, all of the charges Woody had for that backing got dropped. And they did that so they can say that they justified offering him immunity, but they didn't offer him immunity. Woody didn't have immunity Friday, let's say Thursday. He didn't have it Thursday. He didn't get immunity until Mr. Melnick sent Love that email Thursday evening around 6 p.m. and Simone got a copy of it. And then they came in that Friday morning at 8 a.m. The judge said he just signed it this morning. And the judge always speaks, when he's talking about the DA, he's always saying we. We didn't know what he was going to say. We didn't know what we? Are you in Paris? You're talking about we. You're not supposed to be a part of we. You're supposed to be the referee, remember? The referee. Yeah, but I found that awfully strange, the way he did that. And so, I don't know what this one is. I have this one, words unspoken. I did that 2 weeks ago, so I don't need that. Okay, so now I'm going to talk about what I do best. And that is traits of political gangbangers. And I just did Google, and I just Googled gangbangers. And I'm just prefacing it with political. So these are the behaviors of political gangbangers. Gangs are involved in all areas of street crime activities like extortion, drug trafficking, both in and outside the prison system, and theft. Gangs also victimize individuals by robbery and kidnapping. The mindset. Gangs normally project an arrogant and defiant attitude in an attempt to intimidate others, especially in a public place and while in the presence of other gang members. Attitude is displayed when an impression can be made to create fear and intimidate others. Characteristics, and these are all political gangbangers. Those traits consisted of self-centeredness, sense of grandiosity, incapacity of feeling, remorse, empathy, or compassion towards others, as well as emotional coldness and parasitic behavior. These traits resulted in their violating the law and social norms and undermining society structures. Political gangbangers. Signs. They wear jewelry, they do hand signs, they do colors, they do body modifications and tattoos, and indicators of gang affiliation. Gang members have their own language, which contains phrases, hand signs, tattoos, markings, and graffiti. These often overlaps. Those are the traits, and we see that in these people who we call our judiciary. Now let's go, as I want y'all to understand immunity from prosecution. Immunity from prosecution is a legal protection granted to a person that shields them from criminal prosecution for a particular offense or set of offenses. This protection is typically granted by a prosecutor or a court and prevents the government from using any testimony or evidence obtained from the person who was granted immunity against them in a criminal prosecution. The Fifth Amendment of the United States Corporation provides the right against self-incrimination, which means a person cannot be compelled to testify against themselves in a criminal case. However, if a person has relevant information that is important to a case, the government may offer them immunity from prosecution to obtain their testimony. The landmark case of Castigar v. United States, and they give you the number, established the principle that immunity agreements must provide coextensive protection to the witness to prevent any derivative, I'm just sitting up here making up words, any derivative use of their testimony against them. It is important to note that immunity from prosecution can be granted in two forms: use and derivative use immunity. And that they didn't offer him. So that's the catch. And we got to hear the difference. They keep on saying, you have immunity. You have immunity. Well, let's listen to the difference. Use immunity protects the witness from the use of their own testimony against them, but does not, I repeat, but does not prevent the government from using other evidence obtained from independent sources. So that means we're not going to prosecute you for what you say, so you can say whatever you want to say. You just go on and say it. But what they're not telling you is we can get other sources of information and we can prosecute you, and we still got you to do everything we wanted you to do. That's what they're not telling you. But derivative use immunity, on the other hand, provides broader protection by preventing the government from using any evidence or information derived from the witness's testimony against them. It is also important to note that federal grants of immunity from prosecution do not bind the states, and that would be vice versa. States' grants from immunity does not bind the feds. Therefore, if a person is granted immunity from federal prosecution, they may still be prosecuted for the same offense under state law. And I just don't believe they explain that to individuals when they're making deals. And with this group, I just almost 100% know that they're not sharing anything with the people. So I have this document that I found. You know, I'm always finding something. that gives us a little bit more insight on immunity. Regina say, I agree with the corruption of justice. I agree with the unprofessionalism within that courtroom being played out in real time. However, as far as the witnesses, people will be slow to root for them. That's true. And that's sad, because one day it could be them or their child. That's so very true. In my opinion, people of all ethnicities do not feel a lot of compassion for people that commit crimes against others, regardless of what is going on. People want justice to work, and their crimes blur lines. And that is so true. And if people had the same opportunities and they were doing crime, I could go along with those people. But I can see it from all sides. And I'm just as poor as the poor people that's out there doing the crime. I just choose not to do the crime because I don't want to be locked up like an animal. That might be the only reason, because I feel like I get caught. You know, you don't know what keeps a person from doing whatever they do. Desperation makes people do something, and some people just born to do it. They're just going to do what they do. And that's okay. People don't have to feel nothing. But what I do know is, I don't care who it is, everybody have somebody that they love and they care about. And something happens to everybody you love and care about. It may not be the worst thing, but we all have issues and things happen. And we tend to forgive the behavior of those that we love. Don't mean we condone it. Don't mean that we wanted them to do it. But it does happen that way. Yep, she say, but I get it. Yep, multitasking, listening. True that. So, let's talk about this immunity. Hold on a minute. No, I'm not trying to leave the site. I'm trying to take this over here. Is what I'm trying to do. Trying to take this over here. Okay. Before we go, let me let y'all see the signs. Just like, you know how they talk about the gang signs? Let me let y'all just see the signs that I showed before. Let's just check this out. And, you know, you have to use your own mind on what you think and how you. Everybody using sign language these days. Okay. It's a whole document that I found. You know, I'm always researching, trying to find something that help me understand better than what I understand, and help me to be able to tell the story minus my opinion. Try to have as much truth as I can have in the situation, because opinions are like belly buttons and we all have one. And we're all entitled to our opinions, but sometimes our opinions are wrong. And we really believe we're right, but sometimes we be absolutely off the beaten path. So I just kind of Google and ask Google different questions and try to come up with something that I can share. My thing when I came to YouTube was to help uplift fallen humanity give a voice to the voiceless. I don't have the energy, the inclination to get up and get out and march and go and do for people. I've taken people to the doctor and I've taken them to the store and all that kind of stuff, but on a mass scale like LA Pink and the street groomers, those people get out there, like my sister Phyllis, get out there and work hard as a daylight. I have friends, District Clerk Petrie and State Representative Hodge, Deputy Mayor Pro Tem Ms. Arnold. These are people I know personally that I know get out in the community, go visit the senior citizens, send them birthday cards, buy them groceries, pay their utilities. Now, I've paid people bills and I've done all of those things, but I don't have the inclination or the strength and energy to get out and march and vote. I'll write. I can do that. But anything other than that, I can't do. But these people are diligent. They are faithful. LA Pink and several of those young men and women in Atlanta, they go to the Fulton County Commissioners meeting every time they hold one. They are in the top 10 speakers that's there speaking on behalf of other citizens. They are the voice for the voiceless. And there are several people out here making videos that are good videos, but a lot of videos are just money-making videos, and they sound good, but they have no substance. But I guess that's what this game is about, they say. When I came to YouTube, I didn't know that kind of game. I wanted it to be an extra stream of income, but I'm not going to be able to trick and clickbait and lie, and I can't do all of that. I'm too verbose for that. I talk way too much. I'm an analytical thinker. I'm too deep. And I can lie and I can tell tricks and I can talk about people like everybody else. But that ain't the way I choose to live life. I really came and hope somebody would hear something. It'll help them and they can learn something different. But this is out of the Annual Survey of Georgia Law, Volume 32, Article 19, Number 1, 12, 1980. And this is Georgia's Witness Immunity Statute, Explication and Recommendations for Judicial Development. And this is by Roald Mykeltbit. And I hope I didn't mess up his name too bad. But I just kind of want to talk a little bit about the Witness Immunity Statute, Explication and Recommendations for Judicial Development. And it starts with, in 1975, the Georgia General Assembly enacted a comprehensive witness immunity statute providing for a procedure to obtain the testimony of persons who refuse to testify on self-incrimination grounds. That procedure is summarized in the following excerpt from the Act. Whenever in the judgment of the Attorney General or any district attorney, the testimony of any person or the production of evidence of any kind by any person in any criminal proceeding before a court or a grand jury is necessary to the public interest, then the Attorney General or the District Attorney may request the Superior Court in writing to so order that person to testify or produce the evidence. Upon order of the court, that person shall not be excused from testifying or producing any evidence required on the basis of his privilege against self-incrimination, but no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence may be used against the person in any proceedings or prosecution for a crime or an offense concerning which he testified or produced evidence under court order. And we got to hear what they're saying. And see, one thing about legal talk, it's called legalese. And they have words that we think are meaning what we think the words mean. But it's very important when you're dealing with the law, take every word that I just read and look up the definition of that word. First, look and see if they have it in the law dictionary. And then if you don't find it in the law dictionary, go for the oldest dictionaries. Oxford's preferred, but the oldest dictionaries you can find, and look up words. You can even go to the Etymon online, which is an etymology dictionary that gives you the origin of the words and tell you the beginning of a word. I have a word I'd like for y'all to look up, and that word is bad, and you will be amazed at the definition of that word as far as etymology is concerned. The state is not obliged to extend transactional immunity to witnesses testifying under compulsion order issued in pursuance of this law. So see, they're not obliged to give you transactional immunity. Doesn't mean they can't either, but they're not obliged to do it, so they're not going to give it to you. As stated by Georgia Supreme Court, the Act authorizes only a grant of use and derivative use immunity. So they can't give you transactional for that, only use or derivative. But they don't give you derivative. At least they didn't give Woody derivative. They gave him use immunity. Thus, the state may not use the witness testimony or any investigatorial leads derived from the testimony to develop a criminal case against him. If the prosecution can prove that its case was developed totally independently from the compelled testimony, however, it may proceed against the witness without violating his Fifth Amendment right to be protected against compulsory self-incrimination. Furthermore, the Witness Immunity Act does not prescribe the prosecution of any immunized witness for perjury committed while testifying under a compulsion order. Finally, any witness who defies a court order to testify after being accorded use and derivative use immunity by a superior court judge may be adjudged in contempt and committed to the county jail until such time as he purges himself of contempt by testifying as ordered. That's the exact line that Love read when she was telling this judge to tell Mr. Melnick, to tell Mr. Copeland that this is what that says. The law says. The Georgia Witness Immunity Law was enacted just 3 years after the United States Supreme Court held that Castiger versus United States that a federal use and derivative use immunity provision included in the Organized Crime Control Act of 1970 afforded adequate protection for the Fifth Amendment guarantee against compulsory self-incrimination. Prior to Castiger, the Supreme Court had rather consistently maintained the position that nothing less than a grant of transactional immunity would suffice to supplant the great right of the Fifth Amendment. In the leading case of the Councilman v. Hitchcock, the court unequivocally stipulated, "We are clearly of opinion that no statute which leaves the party or witness subject to prosecution after he answers the incriminating questions put to him can have the effect of supplanting the Fifth Amendment privilege conferred by the Constitution of the United States. In view of the constitutional provision, a statutory enactment to be valid must afford absolute immunity against future prosecution for the offense to which the question relates. And so you can have that again when you have use immunity against what you say. But if you don't have derivative immunity, then they can still lock you up. This exegesis of the scope of the Fifth Amendment right was repeatedly reaffirmed by the Supreme Court until 1964. In that year, however, the court initiated a gradual movement away from its established position by its rulings in two profoundly significant cases relating to the question of witness immunity grants. First, in the case of Malloy v. Hogan, the court ruled that the Fifth Amendment privilege against compulsory self-incrimination was fully applicable to the states through the 14th Amendment Due Process Clause. Applying the doctrine of selective incorporation, a 5-member court majority agreed that the Fifth Amendment guarantee was one of those fundamental rights essential to a scheme of ordered liberty and therefore must be protected against state abridgment by the 14th Amendment as rigorously as the right was protected against federal violation by the Fifth Amendment. And that's Justice Brennan for the court averred that it would be incongruous to have different standards determine the validity of a claim of privilege based on the same period prosecution, depending on whether the claim was asserted in a state or federal court. Therefore, the same standards must determine whether an accused accused with an S on it, I don't know how to say that one, silence in either a federal or a state proceeding is justified. Thus, whatever rules and procedures might be adopted to protect the right in federal courts would henceforth be required in state courts as well. Since transactional immunity had been established as the sine qua non to justify a compulsion order to secure the testimony of obdurate witnesses in federal cases, it might be assumed that states under the Malloy ruling would be obliged to adopt the same practice in order to comply with the court's interpretation of the 14th Amendment's Due Process Clause. However, in Murphy v. Waterfront Commission, decided on the same day as Malloy, the court injected an element of confusion into the issue while apparently attempting simply to promote national state comity. Under our federal system, a single act, such as robbing a nationally insured bank, may constitute a violation of state as well as national law. Thus, a person granted immunity by one sovereign, e.g. a state government, in return for his testimony, had found on occasion that his compelled testimony could be used by the other sovereign, the national government, to develop a criminal case against him. An altogether shameful and ignoble arrangement. In a series of cases beginning in 1931, the court had developed the constitutional rule governing grants of immunity in such two sovereignties cases. Justice Arthur Goldberg succinctly surmised the constitutional law relevant to this matter in the following excerpt from his opinion for the court in Murphy. This rule has three decisional facets. United States v. Murdoch, and then there is the number, held that the federal government could compel a witness to give testimony which might incriminate him under state law. And then it gives you some case law. Let me see. Compel witness to testimony under state law. And then it goes on to say, held that a state could compel a witness to give testimony which might incriminate him under federal law, and that gave you the case law. Held that testimony thus compelled by a state could be introduced into evidence in the federal courts. So you can think you're protected in one place and not be protected in another. After an exhaustive survey of the history of the right against compulsory self-incrimination, as revealed in the earlier decisions of English and American courts, Goldberg concluded that the rule described in the preceding passage markedly deviated from well-established principles of law and equity. On the basis of his evaluation of pre-existing case law, and out of concern to promote fundamental fairness in two sovereignties cases, Goldberg, joined by a unanimous court, promulgated a new rule applicable ostensibly only to such case. We hold the constitutional rule to be that a state witness may not be compelled to give testimony which may be incriminating under federal law unless the compelled testimony and its fruits cannot be used in any manner by federal officials in connection with a criminal prosecution against them. We conclude, moreover, that in order to implement this constitutional rule and accommodate the interests of the state and federal governments in investigating and prosecuting crime, the federal government must be prohibited from making any such use of compelled state testimony and its fruits. So I guess that's how they came with the two different types that they're going to offer. It may be true, as some observers have argued, that the Warren Court had no intention of disturbing the councilman ruling by its decision in Murphy. According to the proponents of this position, Murphy applied only to two sovereignties cases and represented an attempt to accommodate federal-state interests by holding that each sovereign must accord use and derivative use immunity to testimony compelled by the other sovereign. The court had adopted a compromise solution to a vexing problem. Witnesses who might have to testify to violations of both federal and state laws were to be granted only use plus fruits immunity by the non-compelling sovereign, thus assuring that prosecution by that sovereign could not be totally foreclosed by the compelling sovereign. Transactional immunity, according to this interpretation of Murphy, must be extended to the witness by the government issuing the compulsion order. The other level of government in our federal system, however, could nonetheless prosecute the witness providing it could demonstrate convincingly that its case was developed entirely independently of the witness's compelled testimony. So that's up to page 5. I don't want to, read out into boredom, but this really explains this immunity that they keep throwing around in that room. But one thing I will give them credit for, they keep saying use immunity. And of course, we don't know what use immunity means. So we just hear them saying that. I'm going to read one more page, maybe two, because I want something to give your mind something to marinate on. Again, like Regina said, a lot of people really don't care about people that are paying for their crimes. But what about when you paid for your crimes? And everybody pretend they're Christian and they so forgiving and loving. But I don't see a lot of forgiving. And it doesn't mean the person is going to do the right thing because you forgive them. You're not responsible for them. And a lot of people do forgive people and end up being harmed by them, but you never know how that's going to go because you can't predict the operation of somebody's mind. You can just look at their actions and then give them whatever grace you want to give them. And it's nothing wrong with you if you don't want to give them grace. You just have to be the captain of your ship. And you can't do it because somebody said that's the right thing to do, or you ain't right because you didn't do that. Now, right comes within you. And if you don't think it's right, then it ain't right for you. But I can guarantee you that the majority of us want to be acknowledged and treated with dignity and respect. And most of us do things to get that acknowledgement and to be treated that way, but we still get stepped on. So we cannot predict what other people are going to do. We can just be true to who we are and do what we say we want to do. And do it to the best of our ability, because sometimes we all fall short of other people's expectations, sometimes even our own. And we have to know that and forgive ourselves and keep moving. It's just what that is. In the course of his opinion for the court, however, Justice Goldberg included a dictum which the Berger court was subsequently to use as the authority for effectively overturning councilmen, emphasizing the scope of the protection accorded witnesses in two sovereignties cases. Goldberg rather offhandedly commented that a use plus fruits immunity grant would place a witness in substantially the same position as if the witness has claimed his Fifth Amendment privilege in the absence of a grant of immunity. Seizing on this dictum, Justice Powell, speaking for the court in Castiger versus United States, argued that whatever the arbiter dicta of the councilman opinion might suggest, the actual ruling in that case was that a grant of immunity must afford protection commensurate with that resulting from invoking the Fifth Amendment privilege itself. The court and councilman had invalidated a simple use immunity law which would have prescribed prosecutorial use of a witness compelled testimony only, while allowing authorities to obtain evidence through investigation. Okay, that's investigatorial. Man, I ain't never seen investigation used like that. That's in investigatorial leads derived from the testimony. I tell you, this reading will wake you up for real though. Castiger, however, involved the question of the constitutionality of a use and a derivative use statute which prohibited a witness compelled testimony from being used against him in any way. The witness immunity provision of the Crime Control Act, Justice Powell reasoned, like the Fifth Amendment, grants neither pardon nor amnesty. Both the statute and the Fifth Amendment allow the government to prosecute using evidence from legitimate, independent sources. So, see, that's why it's important, if you're not going to research and read for yourself, and most of us are not, to confer with a lawyer, and one that knows about this, because just because a person is licensed to practice law, like Nathan Wade, they could just be have a general license and do ambulance chasing, and he doesn't know anything about prosecuting anybody, and he's running around TV talking about how he prosecuted Donald Trump and he called the grand jury and the special grand jury. No, he did not. He was in the room and got paid for sitting in the room. The lady was working people that made hourly wages, or if they're on salary, she was working her employees, while the special prosecutor was collecting $250 an hour to sit in there and watch them work. That's not a belief. It's not an allegation. And they haven't been to court, but it has been before Congress in testimony and proof of the documents. Transactional immunity provided an overly broad and wasteful degree of protection for the Fifth Amendment privilege. As Powell evaluated the matter, the Fifth Amendment, he noted, had been held to preclude use of coerced confessions in Miranda v. Arizona. That's where we got the Miranda rights from, the Miranda v. Arizona case. A coerced confession, Powell observed, as revealing of Leeds' testimony given in exchange for immunity, is inadmissible in a criminal trial, but it does not bar prosecution. The two situations were analogous to Powell. The court had consistently ruled coerced confessions inadmissible in the government's case in chief, but had never ruled that one who had been coerced into confessing to a crime must invariably be set free. Furthermore, a defendant who claimed that he had been compelled to confess to a crime or to make incriminatory, boy, I swear the way they read these words, statements, had to prove at a pre-trial taint hearing that such statements were the products of governmental coercion. On the other hand, as Powell asserted, one raising a claim under this statute, Organized Crime Control Act of 1970, need only show that he testified under a grant of immunity in order to shift to the government the heavy burden of proving that all of the evidence it proposes to use was derived from legitimate independent sources. Thus, the federal use and derivative use immunity law was even more protective of a witness' Fifth Amendment privilege than the court's ruling in Miranda. A ruling generally regarded as manifesting an extraordinarily latitudinarian interpretation of that constitutional guarantee. But they make me feel like I don't know what I'm talking about. Hey, Charlene. Okay, that's fantastic. For all practical purposes, the Castager decision not only affirmed the constitutionality of the federal witness immunity law, but validated priori and properly drafted state use and derivative use immunity statute. So there should have been state use and derivative use statute and Malloy v. Hogan. It will be recalled the court stipulated that the Fifth Amendment's guarantee against compulsory self-incrimination was to be protected against state abridgments by the 14th Amendment's Due Process Clause to the same extent and according to the same standards which were applied to protect that right against federal abridgment. On the same day, Castiger was decided. However, the court terminated any further speculation on this matter by explicitly upholding a state witness immunity statute modeled after its federal counterpart. That decision provided the direct constitutional authority for the implementation of the new Georgia Witness Immunity Act. And I think I'm going to stop there. Well, I might stop. I might read a little bit more. But I did have two videos I was going to show you guys. I got me a little thing for supposedly an Ethernet, but I seen the thing was still buffering, so I don't know if it works or not. It's hooked up and everything, though. No audio? Y'all can't hear me? Okay, Regina, I'm glad, because I was trying to type and ask if y'all could hear me. Y'all know I type slow. But Regina says she can hear. Charlene, I don't know what's happening, because Regina says she can hear me. Okay. I said I was going to stop, but I'm going to read a little bit more. The Georgia Immunity Statute contains no reporting requirement. Therefore, it is not possible to determine precisely the number of times it has been utilized since its inception. So they don't even have to report. You see how these people don't have no checks and no balances? So just imagine how many people that don't look like us that probably get these immunity deal and we don't know anything about it. And we always talking about how many of us go to prison in comparison to other numbers. You think maybe this could be, in that state at least, one of the reasons? And I'm sure all states have some type of similar deal going on. Isn't that amazing? Well, it's just good to read. Reading is fundamental. I swear it is. And if you ever start reading, and I promise, like some of these words, they're words we know, but the way they're using the words, I ain't never seen that. And I'm just doing the best I can. I'll probably be messing up words left and right. But that's why we have dictionaries and we have Google. And I didn't pre-read this whole document. So, child, I'm seeing these words for the first time and doing the best I can do. I've seen the best of the scholars mess up, so I don't feel bad. I just hope I'm not losing y'all, and y'all can halfway understand what I'm saying. Because sometimes I wonder. The Georgia Immunity Statute contains no reporting requirements. I had to read that again. Therefore, it is not possible to determine precisely the number of times it has been utilized since its inception. It appears, however, that Georgia prosecutors have not inundated Superior Court judges with requests for compulsion orders. This conclusion is based on two less than rigorously precise means of assessment. First, informal interviews with several prosecutors and Superior Court judges reveal that at least within their jurisdictions, the act has rarely, if ever, been invoked. Instead, the prosecutors have been able to encourage reluctant witnesses, frequently potential co-defendants, to testify by promising them de facto mean that they're not going to give it to them, dishonest, that's de facto, not real, transactional immunity, or a reduction of charges. Second, the paucity of cases involving the immunity statute reaching the Georgia Court of Appeals and the Georgia Supreme Court further supports the suspicion that the act has not been extensively applied in criminal cases in the trial courts. The immunity statute is hardly a model of clarity, and consequently, if it had been used to compel testimony from recalcitrant witnesses in a large number of cases, one could reasonably assume that a substantially large number of appeals based on the alleged unconstitutionality or misapplication of the act would have been forthcoming. In Powell v. Allen, one of the first cases involving a challenge to the constitutionality of the new immunity statute, the Georgia Court of Appeals determined that the act was in violation of the 14th Amendment due process clause on the grounds that it did not afford a grant of immunity that is as extensive in scope as the Fifth Amendment. Privilege it replaces. As the appeals court interpreted it, the provision of the act which authorized Superior Court judges to compel witnesses to testify in exchange for grants of immunity would not completely preclude a witness compelled testimony from being used against him. Now look at here. And this is what they offering people and offering this young man. And they talking like they doing something. And the judge is telling him, well, young man, we did this. The state did this. And we giving it to you. We ain't going to do nothing to you. But listen to what they said and listen to what happened on appeal. According to Judge Clark, writing for the court, a grant of immunity extended by one Superior Court judge would not be effective in any other jurisdiction. Do y'all hear that? I guess that's why I love myself and I'd just be here if you guys wasn't with me talking to myself. I promise, because I just love finding out stuff. You know, that's how my sister won her appeal. Research and reading. And finding out stuff. And she won in the 3rd District, appellate court. It wasn't no kangaroo court. It was on the Parilla. The only higher you can go is the state of Texas Supreme Court. Reading is fundamental, I promise. And when you don't understand the words, who cares? Get you a dictionary. Look them up. And use your phone. If you can't pronounce them, just type in there how to pronounce this. But normally when you look in a dictionary, it'll let you hit the mic and it'll tell you how to pronounce it. How to use it in a sentence. There is no excuse. Respect. Clark concluded, it is obvious that the Georgia Witness Immunity Statute is defective and of no use if any other court in this or any other state or any federal court could have jurisdiction of the subject matter. Subsequently, in Carson v. Haynes, the appeals court reversed itself, citing the federal case of Murphy v. Waterfront Commission as its authority. In Murphy, the Supreme Court had referred to a grant of immunity extended by a New York court as an act of the state and not the court. Similarly, under the Georgia law, the district attorney and the Superior Court represent the state and are merely carrying out what the state authorizes them to do on its behalf. The state, not the court, is granting immunity. The court is the agent of the state, speaking and acting on its behalf. The Georgia Supreme Court endorsed this construction of the act when it reviewed the case of Corson on certiorari in 1977. The Supreme Court's opinion in Corson contains the most comprehensive exegesis of the state's witness immunity statute to date. In addition to upholding the constitutionality of the law, the court acted to clarify the scope of the immunity which the statute authorized. The caption of that section of the code containing the witness immunity provision reads, "Immunity from prosecution for persons ordered to testify or produce evidence in criminal prosecutions." The court held that this description of the law was misleading because it implied that testimony could only be compelled if absolute or transactional immunity were granted. As the justice unanimously construed the wording of the act, however, it implicated a clear legislative intent to authorize the issuance of compulsion orders based on grants of use plus fruits immunity. The court further held that the new Immunity Act required, at minimum, that the state must grant unconditional use and derivative use immunity to a witness in order to remove his or her privilege not to testify in a self-incriminating manner. In the Corson case, the Superior Court judge acted on the recommendation of the district attorney, had ordered a witness to testify after extending a conditional grant of transactional immunity. The witness was assured that she would not be prosecuted for any criminal act to which she might testify on the condition that her testimony proved to be complete and truthful in every particular. The inference appeared to be that if she failed to provide such perfect testimony, she would be subject to prosecution not only for any perjury she might commit, but for her participation in criminal acts which she might reveal in the truthful portions of her testimony. The Supreme Court rejected the state's argument that an unconditional grant of use and derivative use immunity was implicit in the Superior Court's judge's compulsion order, that by ordering the witness a conditional grant of transactional immunity, he was in effect telling her that her Fifth Amendment right would be protected even more fully than required by the Georgia law, providing that her testimony was complete and truthful. As the Supreme Court evaluated the matter, the trial court's interpretation of the immunity given the applicant was contradictory and ambiguous, and most likely left her with the understanding that she was given no more than the conditional immunity described in the document approved by the court. The court concluded that under the law, a witness who refuses to testify on self-incrimination grounds must be explicitly informed that he or she has unconditional use and derivative use immunity, as broad in scope as the privilege it replaces, before that witness can be compelled to testify. They did not do this to that young man. They didn't say that. They keep hollering use immunity. Use immunity. That's some bull malarkey up the... Everything about this case is fake and wrong, and I don't care what nobody say. That's my opinion, and I'm reading it right here in the law. Regina said, "Oh, dirty Sav." Yeah, you know that's what Funny said when she won. What y'all think about the dirty, dirty? And you know there's a song by Goody Mob. What you think about the dirty Sav? They dirty, dirty. Dirty, 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 dirty. Now I know what that really means. The Georgia immunity statute contains no reporting requirement. Therefore, it is not possible to determine precisely the number X's it's been used. Tell the truth. And we know it ain't been used in hours. We know that. And from what they saying, the way they doing it, it's unconstitutional because you telling these people that they still have their rights when you know in all honesty that use immunity, even derivative, they said, if it's not transitional, then you really ain't got no transactional, you ain't really got no immunity equivalent to the right that you gave up. Ain't that something? It would not be effective in other jurisdictions. You heard that, didn't you? Now, I am wondering if Woody's lawyers explained this to him. If he knows it, I'm sure he did, but his lawyer's not the issue. It's the prosecution and it's the judge. His lawyer didn't find out until a day before he was supposed to testify that he was going to testify. And then he told his lawyer he wanted to take the fifth, because I'm sure his lawyer did explain it to him, and that's why he wanted to take the fifth. But what they did, as I stated, that Friday morning, they got an email that Thursday. That Friday morning, they ran at 8 that morning, the judge signed that immunity deal. That deal wasn't on the table Thursday. They only put that on the table when his lawyer got in touch with them and told them that he was going to take the fifth. He didn't want to testify. And then they planned this because they knew that man was going out of town for 2 weeks or however long his weeks were. I believe it was 2. So they knew he wasn't going to be there that Monday. These people are wicked, wicked, dirty, dirty, and political gangbangers. But what they need to know is nobody is above the law unless you live on the second floor apartment and they can come up there and get you. Yeah, you're not above no law. Yeah, they did that old Woody Wood. They didn't tell them the truth. But his lawyer did. That's why he wanted to take the fifth. And that girl was only supposed to have been going there just to have a lawyer present while he took the fifth. But as that little tape that I showed y'all, when she said, Your Honor, but he fired me before he even took the stand. It makes me believe she was fired that morning when they had that ex parte meeting in secret. I believe they had 2 secret meetings. I don't know if you got to hear the little clips that I played earlier, Regina, but I'll play them again. But I'm going to read this last little bit and I'm going to stop for a minute because I want to show y'all some of the terrible actions of this judge and Miss Love and them, how they acting in this courtroom. And I bought me an Ethernet machine thing, but I don't think it's working real good because it was buffering a moment ago. But I'm going to get it together so at least y'all can just see without interruption. Okay, Regina. See, I'm listening, not typing. Regina said, now here is the boldness of it all in what this Fulton County justice system is doing. It is being televised, and therefore all these discrepancies can easily be pointed out, yet no one is stopping. You got that right, because no one is pointing it out and nobody cares. Most people that talk about this case, they talking about how funny it is, how stupid they are, and have a name that have nothing to do with what's really going on, and got a lot of people listening and a lot of people donating. And that's even these people that call themselves lawyers. They just on here just saying anything. They're not really talking about really what's happening to these young men. And I don't care whose sons they are and what they've done. In this place, they claim we're all innocent until proven guilty. But we know that we're guilty until proven innocent. I mean, we don't even have the support of a people that would want to know, how can this be and how can this keep going on? We won't even write letters to the Georgia bar and go to their website and complain. I think I've even put the thing out there. I don't know if they'll listen to it or not. They might not. But I can't stop what they gonna do. All I can do is my part. And I ain't no different than nobody else. They can do me like they do everybody else. I don't want it. I'm like Brian Steele. I don't want no contempt. But because of who I am, I gotta do what I do. I really have somebody that I love. And I don't want nothing in life to happen to him. But I can't guarantee him nothing. But if I'm alive and in my right mind, I will do everything in my power to be there for him. Because these people are treacherous. And it don't matter who you are. You can't hide. You can't run. You better live. And you better live in all that honor and integrity that you claim you got. If you claim you got some. Because some people ain't claiming it. Yeah, some people ain't claiming it. But I claim it. And I'm going to help whoever I can. The best way I can. Sometimes to my detriment. Right now, it's to my detriment. I gave to ungrateful people and don't have a dime. I have to pay so much in interest on them credit cards just to try to keep my name. Oh, it's hard. But it is what it is because I did it. Nobody made me do it. I didn't even know how much to give. I overgave. I did my best. That's all I can say. I did my best. And I do my best. But I'm looking for this thing so I can put it in here. This, I thought it was right in there. I don't know. I must put this in somebody else's thing. This must not be my check. Because I know I got it. Yeah, here it is, to file a complaint. You know, a lot of people say they don't want to get involved because it ain't got nothing to do with me. Not today. And you think it doesn't have nothing to do with you. And Regina said, but these are the things that the people in the legal field talk about amongst their peers. Why? Because the lawyers are paid representatives for their clients, and it is unethical to interfere. Now we see why, don't we? It's unfortunate to say this, but it's the way, that way in most fields. It's that way, I would say, in 99.9. And we can only give them that 1 point because we know it ain't all or nothing. Just like it ain't all bad people in these professions. But it ain't all good either. And all that the good outweigh the bad. You keep believing that. And see how your life living. And the people around you living. You might be living good. But just look at the people around you and how they living. Yeah, it just sound good. Makes for a good storyline. But I'm here to tell you. Those who have rights and don't claim their rights are no better off than those without a right. Nobody is going to help you. And they don't see you trying to help yourself. That's just not going to happen. That's just not going to happen. I've asked, we have 7 people I'm showing. I'm very excited about it. Now it's 6. If you all remember to hit the like button, please hit the like button for me. Hit the subscribe button if you haven't subscribed. If you could subscribe, hit my membership. I have membership as low as a cup of coffee. I hear other YouTubers say that it sounds good. The price of coffee a day. And it helps me to receive a check. Helps me pay for this stuff I be buying to try to make sure I have a great show. I'm not down with the editing and stuff yet, but I'm just trying to get the stuff to show so I'm not cutting off and y'all can't hear me. But I really thank Law and Crime because I use a lot of their videos. And you know, everybody always tell us to share until you share their stuff, and then they seem to be perturbed. They didn't mean for you to share like that. So I just try to do the best I can with the little knowledge that I have, because I don't have a lot. But I'm learning. I'm learning so much more. And I'm learning that most people, they all run kind of like in little groups and little packs. And they support one another. Rarely do they support you. If at all, because you never see them. But all I know is, if you keep coming back, whoever you are, I'm going to keep coming back. Because I am who I say I am. And I'm going to do this for as long as I feel like doing it. Health-wise and mental-wise. You know, I really tell myself I couldn't be a Martin Luther King and whoever these people are. Number one, I'm not a sellout. But number two, it's very hard to fight for people who are not even interested. I mean, the least bit interested until it affects them. Then they want to absorb all of your time and want you to help them and tell them what to do and do it for them. But it's about self-preservation, self-esteem, self-worth. And you got to do it, because what I had to learn is some people don't want it. And they're not going to get it. Regina said, thank you to everyone that has hit the like. Thank you all beforehand to all those that will catch the replay, subscribe, and like. You are appreciated. Yes, 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 you are. And like Regina said, that would catch the replay. Because everybody can't come to a live. And I understand that. Okay, so I was down close to the end. The Supreme Court refused formally to rule on the question of whether or not an unconditional grant of transactional immunity given by the prosecutor and approved by the court would be valid absent statutory authorization. By affirming the Court of Appeals rationale, upholding the constitutionality of the new witness immunity statute, however, let's go on down. Now, I know I read however somewhere. I have to go from screen to screen because I can't see all the way at the bottom. So let me see. It's got to be in here somewhere. State Superior Court does not confirm statute by the court due to acting state court. State acts through the period to extend. Very rid of great transaction immunity. Georgia immunity. I swear I don't see no however on this page. Derivative immunity and protection of the statement is grant a transactional immunity and even ratified by Superior Court judge conceivably. So it's got to be up before that because I hadn't read that. But I swear I don't see no however. And I saw a however a while ago. Just a little while ago. Maybe I went up too far. Boy, you know that's terrible when you get lost. But I know that word however was in here. I'm got a peppermint in my mouth. There it is right there. I found it, y'all. I found however. However, the Supreme Court certainly cast doubt on the constitutionality of any grant of immunity extended by a superior court which does not conform to the letter of the state statute. It should be recalled that the Court of Appeals held that a grant of immunity extended under the terms of the witness immunity statute by a superior court judge was an act of the state, not the court. The state acts through the judges to extend use and derivative use immunity from prosecution in all state courts in exchange for a witness testimony. A grant of transactional immunity informally promised by a prosecutor, even if ratified by a superior court judge, conceivably would not suffice to displace the Fifth Amendment's privilege unless the superior court judge also formally invoked the Georgia immunity statute and clearly apprised the witness that he or she would have unconditional use and derivative use immunity as well. If the latter condition were not met, the grant of transactional immunity would presumably not be valid outside the jurisdiction of the court compelling testimony. Now you think that judge and them prosecutors don't know that, why they keep telling this boy they giving him all this immunity? Y'all think they don't know what they doing? Why they pretending they don't know that they messing over these children and these young men now? But just think about it. Are they really men? You know, you stop developing emotionally and sometimes intellectually, whether trauma enter your life. And most of these kids grew up with trauma and were in special ed classes and were on medications and then start self-medicating. And can you believe it? Through all of that, the brilliance of their minds gave them the ability to put beats and words together. And now we got these crooks who went to school and paid money and owe money and probably cheated through school. That's my opinion. And they mad at these kids because they put some beats and some words together and now making more money than them. So now what are they doing? They get government jobs, get government grants, and then pillage the money. And then they're all trying to live like they superstars. It is just something wrong. We need a complete overhaul. Thank you, Regina. Tell the truth. They don't keep no checks, no balances. They said that, not us. We didn't say that. That's why I'm so glad Astor told me. Because I used to just be reading. He said, no, Toothless, it gives more credibility when you show your source. And it does. Okay. And it goes on to say money, since the immunity grant would have been authorized by the court and not the state. While conceding that the Fifth Amendment itself, actually the 14th Amendment due process clause, which makes the Fifth Amendment right applicable to the states, would have prohibited the use or derivative use of the appellant's testimony had she testified, regardless of the validity of the immunity grant. The Georgia Supreme Court held that this fact was irrelevant. A superior court is not justified in violating state law simply because such a violation, if noted and used as the basis for an appeal, would be corrected by the invocation of the federal Constitution. Rather, the state must grant a valid immunity under state law as broad in scope as the privilege it replaces, and demonstrate the applicability of that state immunity to the witness before ordering her to testify. They didn't do that to this young man. They locked him up. Locked him up. The rationale of the court's position appears to be that since the General Assembly enacted a statute which provides for a forum of immunity conterminous with the privilege against compulsory self-incrimination, that statute must be applied by the trial courts as the only basis for issuing compulsion orders. Apparently, a prosecutor may continue to bargain with prospective witnesses in order to obtain their testimony, to offer transactional immunity, for example, in exchange for their testimony. Witness may not be compelled to testify by judicial order, however, solely on the basis of a district attorney promise not to prosecute. That's just what they made that boy do. That young man, I'm going to say. That's just what they made him do. That's what they say it ain't supposed to do. Furthermore, if testimony so compelled is used in a criminal prosecution, it might well constitute a reversible error on appeal. So vigorously, and see the judge keep talking about on appeal. Do it on appeal. And I think they're doing that because they want to use up all of that money. Because all of the ORCA money expires at the end of December of 2024. I don't think they're doing this stuff for no justice. Now, they could be. I don't know these people. But their actions, I know their actions. And they're not honorable. They're not just, and they're not integral. And I don't care if he's serving the reserve, if he is a brigadier general, they say, if he was the commander-in-chief, if he was the chief of relief, whoever, it doesn't matter. But nothing is right about what this man and these people are doing to people in Fulton County. And I can't make Fulton County get upset about it, but it's some people already fighting for people. Virginia said, how dare these thugs be famous and rich? I should be a star. Says all the look at me wannabes. Oh, the irony of it all. Why do I feel another speech at a Southern Baptist church coming? It's coming. It's coming. It's coming. Uh-huh. You can believe it's coming. Back to multitasking and listening. I'm glad that you're listening and multitasking and participating. Y'all, this is really sad what's going on. And like I said, it's a lot of people reporting on this story, and they got thousands of people in their chats. And they get hundreds of dollars. But they're not talking about reality. They're talking about the Hollywoodism of it. Man, this ain't no Hollywood for these young guys. This ain't no Hollywood for their families. This ain't no I'm trying to get a deal. This is real life. And I guess, that's why don't nobody want to listen to what I have to say, because nobody want to deal with real life. But I thank y'all 8 people that are listening, those that come and those that go. I would ask that you hit the like button. If you're not subscribed, please subscribe to my channel. I have membership. Consider joining my membership. I have membership as low as a cup of coffee a month. Not a day, a month. Even a day. Y'all, it's real out here. And we hurting as a people. And we wonder how and why and when is it going to change. It's not going to change until we give up the entertainment factor and start learning some stuff. And start applying what we learned. It's not going to change. And a lot of us are older and set in our ways, so we may not do it. But we should be learning to teach the younger children. Or at least put them on the path. You don't have to know everything. I don't. But what I know, I know. And I seek knowledge. I seek it like the air that I breathe. And I try to teach it to whoever will listen. There's only so much they'll let us say on their platforms, and I respect that. But there's so much more to say. But if you knew too much, you'd go back to sleep. Because most people ain't moving no way. Not in the way that's going to help us as a people. And you don't have to save the group. Charity begins at home and then it spreads abroad. So start with your little nest. And they will go out and share. Whatever you put in them, that's what's coming out. That's how you have so many of these kids in the schools, these little Europeans, calling all the children all these names and fighting on them and hitting them upside the head. But yet we can't talk about history because, that's the critical race theory. And, you trying to put too much embarrassment and too much pressure on our children. Has nothing to do with your children in that respect. It has to do with our children to know a lot of that stuff they told us was a lie. That's number one. And let's then learn the truth. And a lot of people that keep us oppressed and down look just like us. We got to get honest. Hi, Moon Child Pink. Okay. 110-degree weather. All is well. I'm glad you got to get away. Hope you're doing well. Have fun. Hope you win. Yeah, y'all, we just don't even understand how so serious this stuff is. But, it don't have to be serious for everybody. It really doesn't. It does not have to be serious for everybody. But I'm just going to do my part. And whatever happens, happens. Because I can't control nothing but me. And I do my best. I do my best. Okay, so I'm going to get ready to stop reading. Where did I stop at? Because I really want to show y'all, they're not real long, but I want to show y'all some of the moments in there, how this case is going. Everybody knows it's a circus, We know that the Superior Court is not justified in violating state law. I read all of that. I think I was down close to the bottom. think I was that the only constitutional means of obtaining compelled testimony. A question of considerable import not presented to the court in Carson is whether or not the state immunity statute requires superior court judges to issue compulsion orders when requested to do so by the prosecution in a state criminal case. The law stipulates that the Attorney General or the District Attorney may request the Superior Court in writing to so order a witness to testify. Upon order of the court, the act continues, that person, the prospective witness, shall not be excused from testifying on the basis of his privilege against self-incrimination. The wording of the act thus suggests that a judicial compulsion order will be forthcoming following submission of an appropriately worded request. Nevertheless, the fact that there is no clearly stated requirement that Superior Court judges issue such orders affords the Supreme Court an opportunity through statutory interpretation to read judicial discretion into the act. The Federal Witness Immunity Statute, which was extant as the time of the Georgia statute was drafted, and which is effect, had been commended to the states as a model law of the United States Supreme Court, and Castiger contained a proviso specifically obligating federal judges to issue compulsion orders when asked to do so by the prosecution. Therefore, it could be argued that the omission of a similar provision from the Georgia statute was reflective of a legislative intent to accord Georgia Superior Court judges the authority to evaluate the desirability of compelling testimony, given the totality of circumstances of each criminal case. So it wasn't given to them the same way with the federal judges. So just like he just said what he got to do and he's probably going to do because they're compelling him to do, that ain't got nothing to do with nothing. He wrong, it's two left shoes. From what they're saying. From what I understand that to be saying, my understanding could be wrong. I doubt it, but it could be. I have a question, Regina said. When is the trial starting again? Good question. Because tomorrow, I believe he's supposed to allow the defense attorneys to hear and see the redacted transcript. But again, I believe there was 2 ex parte meetings. And if these people are slick enough to do what they're doing, I believe they had a meeting Friday without Woody and without Miss Bumpus and the other people. And then they had that one Monday morning. And I only believe that because she said in open court on that day, I played it, and I don't know if y'all heard it, Regina. I'll play it again. But Miss Love requested an ex parte meeting with the judge. So they wasn't arguing about that one. That's why I believe they had that Friday. And they wouldn't have been so shocked about them having one Monday morning. The judge could have told them, because it's on record, it's on the video that they asked for it. One moment, please. It's something about talking for a minute Your head gets stopped up. Okay, so I believe that these people would do anything after reading this and seeing how they're doing. And you know one thing too, these case laws, they called out a case law and they was like they really was saying something. And the case that they called out, Brian still knew the case so well because he's the one who handled the appeal. These people don't even read their own case law to know it was his case. It's just unbelievable. But that's another thing. Whenever you're reading petitions, it's always good to read whatever case they have listed in there to see if that case has anything to do with whatever your case is. Because attorneys will just throw case law in there knowing people ain't going to read it. Not even some attorneys, because you got to start out new. And they just teach you how to do a job. They don't teach you your job. I think I can send you the link. I would try when we get off the computer. Yeah, this is very interesting, I'm telling you. Okay, let me finish because I'm running out of time. Relatively, is that where I started? I don't know. Let me just go back up here. Therefore, it could be argued that the omission of a similar provision from the Georgia statute was reflective of a legislative intent to accord Georgia Superior Court judges the authority to evaluate the desirability of compelling testimony, given the totality of circumstances of each criminal case. Relatively recent federal cases indicate that Georgia courts would be on firm ground constitutionally to claim substantial control over the issuance of compulsion orders. The application of the federal immunity statute as a prosecutorial weapon exclusively has been challenged persuasively on due process grounds. There are now indications that federal courts are no longer going to acquiesce automatically to every government request for compulsion orders, despite the wording of the federal immunity statute. Federal appellate courts, as early as 1966, had adopted the position that it would be a denial of the fundamental fairness required by due process of law if government were to use the immunity procedure to compel testimony from prosecution witnesses while refusing to apply for grants of immunity for important defense witnesses who might have refused to testify on self-incrimination grounds. In the leading case of the United States v. Alicio, the United States of Appeals for the Ninth Circuit finally ruled that such a denial of reciprocative, we got to get right here. I think that's where it is. Where's the application? The Ninth Circuit. Okay. Oh, no, that's not reciprocative. That's reciprocity. I see it down here. Reciprocity by the government would violate the Fifth Amendment's due process clause. The Alicio opinion furthermore advanced the following principles relative to the application of the federal immunity statute. Number one, the executive branch of the government has exclusive authority and absolute discretion to decide whether to prosecute a case, and consequently cannot be compelled by the courts to extend immunity to a prospective defense witness whom it may wish to prosecute. Number two, The executive may not use the exclusive authority, however, in a manner which denies the defendant the due process guaranteed by the Fifth Amendment. And number 3, in each case, therefore, courts must determine whether the defendant would be denied a fair trial because of the government's refusal to seek immunity for the defense witness. And on that note, I'm going to stop at page 12. I'll take that up on Wednesday. I'm going to go ahead and do this, highlight that so we'll know where we are. And I want to show y'all, let me see which one is short.
You explained, you just heard.
Let me give me a minute. I want to see which one's shorter in time. This one is not the shortest in time.
Yeah.
Do you want to be?
But I think I want to go on and show this one, because this one is the one where she asked him questions that I said. She asked him that stupid question so they can justify that he got to testify under the immunity. And they knew that he was going to say he wanted to take the fifth. And the judge actually said, well, she only asked him what was his age. That was on purpose, y'all. All of this is a play. These people I don't know if they're trying to get a Netflix deal, a book deal, a movie deal. They don't care anything about these kids' lives. They call Atlanta the Black Hollywood. And I don't know what these people are trying to do, but justice is nowhere around this place. I mean, justice is blind. Their justice can see exactly what they're doing. And I just want to show y'all that. I don't know if y'all heard me talking or not, but justice is nowhere near that place. I don't know if this is Hollywood. They call Atlanta the Black Hollywood, the Mecca, and all that good stuff. Honey, I'm going to tell y'all, these people are doing worse than it was in the 1800s. They are really doing it bad to our sons and daughters in the name of gangs. Fonnie and Love ran on gangs, but they seem more of a gang than any of these children. We all grew up. We all hung out with our friends. Some of us dressed alike. Some of us didn't. I mean, come on. We haven't forgot what it was like to be young. And back then, we didn't have crack cocaine. And we didn't have mothers who ran off on their babies so she could get a bump. And everybody laughed and called her a strawberry or a rock star. A lot of these children have been through some things, and everybody's mother and father wasn't like that, but a lot of people were. In all communities where we live as a people. I know that people don't forgive and they don't believe in second chances, but they love the Lord with their whole heart, and He heard they cry and pitied they every groan and moan. I know it's all about them, but it's a us, it's a we, and it's a me. It's all of that. And we got to help the weak. That's what it says. The strong is supposed to bear the infirmities of the weak. We can't make them want it, and we can't make them get it. But it's some people who want it and don't even have a clue of how to get it. And if they had, they would do it. It's some people walk to work because they don't have transportation. And it ain't because they too proud to ask nobody. Everybody they ask can't help them. And everybody that can help them, if they'd have just called them yesterday, they'd have helped them. I know that feeling oh too well. And out of all the people I helped, I didn't help them because I thought they were going to be the ones that helped me. But I sure would love to see one or two of them be the one that helped me. But I don't even feel comfortable in asking. That's how life will do you. I gave, and my mama taught me to give out of the abundance of my heart. And I did that. On borrowed money, borrowed time. If you needed help, and if I could help you, I didn't realize I was hurting me. All I know is I saw somebody with a need. And then I tried to help them. I hear a lot of people tell that good story, and it sounds real good. Makes for a good storyline. But it is what it is. But I want y'all to know, we got to fight for our children, no matter how old they get. Because these babies, some of them didn't have a ghost of a chance. And the one that had a daddy in his life, 2 of them had daddies in their lives. Doing pretty good. Smart young men. They want to be like them. They want to be like Thug. They want to be on the radio. The detective said he followed him on IG. And then, I don't have no Instagram. But you just said that in court, sir. I just have my word. No, you got 2. And then they giving more testimony than Woody. But they impeaching Woody, they say, with everything. But they're not telling the truth. And then we got everybody and their mama telling the story and gonna break it down. But they're not telling the truth. But it sounds good. It does. It makes for a great storyline. Let me let y'all hear this, please. And Regina, I want you to tell me what you think. Because I know this lady asked him this line of question, because she knew he was going to take the fifth. And they knew. Hold on.
I'm here.
Okay. Well, are you gonna let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, good.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody. Before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right
I don't
now.
want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
Do what I need a lawyer for? This, what
No,
do I-
it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
Well, Judge, just for the record, I was never his counsel.
Say again?
I was never his counsel. Attorney Melnick was his counsel, and I was stepping in as a courtesy for judicial efficiency. I was motion to withdraw.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have, because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
The judge is really overdoing it on that. That man know that he can't hire no another lawyer, and he already has a lawyer. That's unethical. Everything that judge is saying is unethical. And I don't practice law. I'm not no lawyer. But I know that. I mean, it's just really crazy what this man be saying. And it's a lot of people cover this story. It's a lot of Europeans cover it, and they cover it good, but they're not covering it for the reason we covering it. And we don't even care. Because we just want subscriptions. I want subscriptions. We want subscribers. I want subscribers. We want donations. I want donations. Everybody does. That's why we're here. But I also want to give real information. People can research this stuff. You don't have to take my word for it. But I have it. It's unbelievable. This is so disheartening to me. All that craziness he's saying, like he really saying something legal. And it could be legal, because we need to know the difference between legal and lawful. You know, once slavery was legal. There's a whole lot of things that was legal. Some things that were illegal now are legal. Just ask the pronoun. It's crazy.
But I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
I do get right.
You do, yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you get to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw. But you're on the stand. You're testifying.
Okay, Regina, that's what I'm talking about. See, I really believe they had an ex parte meeting Friday. And I don't think she was included in that one, but she could have been. She and Bumpus and Simone are friends. They're not sorority sisters. They're just friends. Bumpus says she practiced in Texas and in Atlanta, but I looked her up the other night, and I swear I was getting ready to tell her story, but I looked at the lead attorney, because now they're covering the story, and she was on there letting them know that she doesn't have license in Texas. But I looked her up, and I know she didn't have license in Texas. None of that made sense to me. But what she was doing was just standing in for the man who they did not let know that his client was going to be testifying. He found out the Thursday before he was going to testify. And he was going out of town Monday when the judge said he'll bring him back, because the judge arrested him when he took the fifth. And the man said, I couldn't be there because I have tickets. I've been on the calendar since December of 2023 with my vacation. Judge, I've already paid for everything. And they tell me, well, you must not be interested in your client if you're going on. What kind of stuff is that to say to somebody? He was on the calendar. That's why I believe they chose that week to do what they did. They know exactly what they're doing. Bumpus, she knows the Melnick man, and she knows Simone. So she was just coming there so that he would have an attorney with him, because he said he was coming back Monday to plead the fifth again. He was just going to sit out 2 years in jail. But in the ex parte meeting that morning, they told him that they're going to make him sit out until everybody is tried, which is 26 different individuals. And those other guys don't even have lawyers. That was such a joke the other day. But they look like they have a more serious judge. I don't know if he knows law or not. But he looked like he takes it. He's not just looking for fame, and then he could be Red Sample type. I don't know. Fred Sample. I'm talking about Red Sample. Fred Sample type. I really don't know. This stuff here is beyond belief. But this goes on every day in somebody's courtroom. These are the type of things that go on, and everybody think everybody that holds an office or a title is so honest and integral, like we little regular people are not. It's so unbelievable, and it's so very disheartening, especially as a mother. It hurts so bad. As an auntie, as a cousin, as a friend, this stuff hurts. And I don't take it to heart where it's killing me and I can't sleep and stuff. I just take it to heart as a mother and a woman who know that life could be different. Only if people would just try to learn and do something different. Just like they learned the scripture, they ought to be learning these laws, because in the scripture it tells you Jesus fulfilled the law. We know that's not true, because we see this happening every day. Our kids are going away based on the law. And nobody is there to help them. Not even their own people. You may put up money, but I try to teach people to just go and look at what they're talking about and read it. And read it until you understand it. You may not understand it the first 20 times. You may not. But keep on reading. It'll come to you. I promise you it will. And then I'll be reading stuff. Sometimes I'll be wondering if I'm dyslexic. I'll be misinterpreting stuff. But you just keep on reading until you get it right. Regina said, I'm sorry, but this Miss Bumpers representative is just as incompetent as the rest under D.A. Willis. Yeah, she's not. She used to work in the DA office under that other guy, Paul Howard. And she's supposed to have her own practice now. And she's supposed to live in Texas and supposed to practice in Texas. But like I showed in one of my videos, I think it was the one the other day, Wednesday, when I pulled it up and showed y'all that when you put her name in the bar, she's not there. She doesn't practice here, but she said it's some kind of way, kind of like a grandfathered in, but she called it something, and it might be something. I don't believe that, but if that's what she say, then that's what she say. But I know no one state, according to the Constitution, has to honor the laws of the other states, so I don't see why they got to honor their license. And I don't know them honoring their license and anything else. You got to be licensed by the state of Texas, the state of wherever you go, for you to be able to practice in their jurisdiction. But hey, what do I know? I'm not no attorney. I don't know it all. Like I said, the little bit I know, and I share with the people. The little bit that I don't, I'm not sure of, I tell the people, research for yourself. Don't never take my word for nothing. Because I could be wrong or misinterpreting something. 9 times out of 10, I'm not wrong. I might misinterpret some stuff. I'm going to tell you, I'm going to do everything I can to find something that verifies what I'm telling you, because I don't want to just tell you anything. And I'm not suggesting nothing. Well, I'm suggesting knowledge, so that's a lie. I am suggesting knowledge. And I don't advise people to do nothing. You do what you want to do. Yes, Regina. It's been the way of this land forever. That's right. And see, before, though, we didn't get a chance to run in these venues. And we swore. That's what bothers me. When we got the opportunity, we were going to do the right thing. And you know what? I can understand some things you having to compromise. And I can understand doing some things wrong. You know, we're all human. But everything you do is what you say they did, and you're not doing anything different for nobody but your own. You believe in the charity begins and stays at home. It's supposed to begin at home and spread abroad. So if you can help your babies, help somebody else's baby. It's not right. But who said it would be? Let me go back to this because I could preach forever.
At this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr.
The judge has never really acknowledged Mr. Melnick as being this man's attorney for this issue. He was his attorney for this issue. And he hasn't never acknowledged that. Even when he told him that Miss Love knew, and he went back and looked at the emails, he didn't ask her not one question. He didn't say, do you have proof? Do you have it here for the court? He wasn't interested in none of that. He cut everybody off but Love and Hilton. But now he's been more lenient and more kind to the defense, because now he knows the ball is in somebody else's court. Huh.
Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days. But until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business that...
Also, can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
You may answer the question, sir.
Do you recall? I'll ask the question again. Do you recall Thug and Kel speaking while at the Cascade Skating Ring in 2015?
I don't recall.
Okay. Do you recall telling Detective Gaither about that phone call?
Yes.
Okay. What do you remember telling Detective Gaither about that phone call?
My word for word?
Whatever you remember.
Oh, I don't know. I don't recall.
Okay. Do you remember first telling Detective Gaither that you and Kel had said that the beef was over? You told Detective Gaither that.
Yes.
All right. Do you recall, again, telling Detective Gaither in this interview that Kel asked you to call Thug?
Yes.
Do you recall what Thug said in 2015 to Kel?
Yes.
Yes, you remember what Thug said?
I don't recall what was said. I don't remember what was said.
Okay.
I don't remember me talking to the investigators about it.
All right. Do you remember telling Detective Gaither that when Kel got on the phone, that Thug said the beef ain't over with until you pay for my window? You shot my window.
Yes.
Yes, you remember telling Detective Gaither that?
I don't remember what I done told the police.
Okay. Let me ask you this. Are you just saying yes now to speed up your question?
Most definitely.
Okay. Now, do you recall independently that after Thug told Kel, beef ain't over with until you pay for my window, you shot my window, that you told Kel what you told Kel?
Yes.
What do you remember telling Kel?
Yes.
So you told Kel, yes?
Yes.
Do you recall telling Kel, look, what y'all got going on, this has nothing to do with me?
Yes.
Do you recall also that you told Thug that your beef with Kel is over with?
Yes.
Do you recall what Thug said to you after you said that?
Yes.
What did he say to you?
What did who say to me?
What did Thug say to you?
When?
While he was on FaceTime at the Cascade skating ring.
Who was on FaceTime at the Cascade Game Ring?
Do you remember testifying earlier that you told Detective Thorpe in January 11th that Kel and Thug...
I don't remember what I told the investigator or Detective Thorpe or whatever.
Okay. Do you remember telling Detective Gaither in this January 28th interview that Thug said, nigga, I don't care about none of it. Look what y'all got going on. You still shot at me. Just pay for my window. You gonna pay for my window. Hey man, I ain't letting that go.
Yes.
Yes, you remember Thug saying that?
Thug say that?
You said yes, so I'm asking you, what do you remember?
Cause I keep telling you I don't remember. You keep asking me questions, so I'm just saying yes.
Okay, so are you saying yes, that's what you told Detective Gaither?
I know I ain't complete school, but I think I'm speaking proper English. I told you, I don't recall nothing I said to no polices. You keep sitting right here asking me the same question over and over and over and over and over. I'm tired of it. I'm drained.
Okay. Well, if you would just answer the questions
I
properly.
am answering the question. You asked me, I said yes, yes. When I say yes, you ask me the same question over and over and over and over and over.
But did you just tell the court and this jury that you're saying yes just to move the process along?
I think I said it loud and clear.
So again, will you just answer the questions and we can move the process along?
You keep asking, okay, yes.
What are you answering yes to?
Your question.
Objection.
Yesterday, did you tell myself and my colleagues, Ms. Love and others, about Little D and Shannon being in your vehicle the night of the murder?
Huh?
Yesterday, did you tell myself, Ms. Love, and a few of my other colleagues that Little D and Shannon were in the car with you the night of the murder?
Now she's asking him on the record, yesterday, did you tell myself? Now this is not Hear me good. This is not in the ex parte meeting. This was the Tuesday after ex parte meeting. They took him back in the room in the back, in the courtroom, and had him sign documents. And that's when Mr. Steele was telling the judge that they need to watch how these people are, all around him, the DA and the sheriff, the bailiffs, everywhere he go, it's like he's got a Secret Service brigade going with him. So she's saying yesterday, like that's going to she just said, do you remember telling me? Like they're talking about the ex parte meeting. But if they were talking about the ex parte meeting, then that means they were talking about substantive stuff, right? But this is crazy. Just keep listening.
Of Dallas House.
I told you and them that what I told investigators in June, when Nut got killed, something different, because I was trying to finesse my way out of a situation. So I said, I picked up D and Shannon. D never told me nothing. I made it up to clear myself up. And that's it.
And was that yesterday that you said that? Did you tell us that yesterday, what you just said?
You asked me to be truthful. And I didn't. And I told you. What I told the investigator back then wasn't me being truthful. So I'm telling you something that I didn't tell them because I ain't trying to go back to jail.
I got it. But actually was yesterday. The first time you said this part, and now what you're saying today is what is truthful. What you're saying right now, what you're trying to tell the jury right now, is what you are now saying is truthful.
What I'm trying to tell you is our conversation was about something that I said in the past.
I understand. I'm asking you.
I asked that Mr. Copeland allowed to finish his.
Okay, all right.
I'll tell you what's up.
Mr. Copeland, you need to finish your answers?
No, I need a break, Yana.
Say again?
I need a break.
You need to use the restroom?
No, I need a break. Like, I need a break.
Sir, it's not time for us to take a break at this point in
Well,
time.
okay.
Okay? I mean, unless you need to go to the bathroom or some other reason, we're not gonna break at this point in time.
Do you need a few moments? Was yesterday the first time that you told?
Your Honor, I asked Mr. Copeland to finish his answer if he was still.
I don't think he's finished. I think he's finished, Mr. Steele. So I'll overrule that objection.
Was yesterday the first time that you told anyone from the state that what you said back in January of 2015 was a lie? And that you were trying to finesse your way out of what you told them back in January of 2015?
I told that to the investigators when they was questioning me at a certain point.
What investigators?
Y'all questioned me so many times, I don't know.
Back in 2015, did you go to the police again on January 11, 2015?
I'll sustain the objection.
Did you also go to the police on January 28, 2015?
I don't know no dates, but if you know that if I went to the, you could just say it.
Did you also go and speak with the police on February 20th, 2015?
If that's what it say.
And what about on February 21st, 2015?
If that's what it say.
And then what about on June 10th, 2015?
If that's what it say.
Let me ask you this. In your interview on January 11th, 2015, do you recall your girlfriend's mother's home being shot up?
Was it?
Do you recall it? I'm asking, do you recall her mother's home being shot up that night after Nut was killed?
I don't know if it was the same night or the next night.
Do you also recall that the stepdad's house was shot up that same evening?
I will object to.
Basis.
Meeting here.
I'll sustain this to form. You can rephrase me.
When the young thug stepdad's house shot up the night that Nut
I don't know.
got killed. When you went to the police station on January 11, 2015, did you go there on your own?
Nope.
Did the police come and get you to go to the police station, or did someone drop you off? Come on, son.
They,
I'm gonna overrule the objection.
Did you voluntarily go down to the police station that night?
no, I didn't volunteer. He called me.
And did he tell you you had to come down there, or did you decide to go down there yourself?
Well, he told me to come down there. And people told me to go down there because
No, you're on.
Is there an objection, sir? And just state what it is.
Still talking.
Okay, let me see if he's finished his response. Mr. Copeland, are you finished? Or do you need to say something else to complete that last question you were asked?
yeah, I'm just gonna say that I was told to go down there and speak with the police.
Okay, all right.
Do you recall in 2015 telling law enforcement officers that you were calling to get advice on whether or not you should go down and speak to the police because your name was coming up in the murder?
Can you say the first part again?
Do you recall telling Detective Thorpe in his January 11, 2015 interview that you were calling around getting advice to decide whether or not you should come down to the police department because people were putting your name in the murder?
I don't know. I know when he called me, didn't know what to do, so that's why I was told to go down there. 'Cause- yeah, I'm finished.
Do you recall telling Detective Thorpe in that same January 11, 2015 interview that people told you not to go down there and to wait till the police called you? But you wanted to come down so you could clear your name.
He said, did I tell him that?
Yes.
I guess.
In that January 11, 2015 interview, was Thug in that interview with you?
Huh?
When you went to go speak with Detective Thorpe on January 11, 2015, was Thug in that interview with you?
What you?
Basis. Okay. Mr. Copeland, can you step outside for just a second? Ladies and gentlemen, jury, can I get you to step in your headquarters just for a minute, please?
Do you recall them asking you some more questions about Tay, and you providing them information about where Tay was from, what part of Atlanta he was from?
I I don't recall.
Okay. Do you recall the detective asking you, we only know there's a guy by the name of Tay. Where's Tay from? What area he live in? And you told him that he was from Simpson Road area. You recall telling the detective that?
I guess I don't remember what I said to him.
Do you recall?
Because at that point he had put too much pressure on me, and you know what I mean. I'm just thinking because he told me. I remember him saying he want that gun. That's all I remember him kept saying. He want that gun.
And when you say putting pressure, what do you mean?
Same thing you doing to me now. You keep putting pressure on me.
Okay. Was he yelling at you at all during this interview?
I think he kept saying, I'm letting people shoot at me while I got my child, and my loyalty to the streets, my loyalty to my child.
Okay. So was he just trying to get you to tell him who did this to you, your child and your baby?
I stand the questions to form.
Did he ever threaten you to give a name?
Nah, but he kept asking me to make me say a name, and like how you keep asking me a question. I'm gonna say something to answer you, so you can stop asking me the same question.
Were you concerned about how you were going to survive the attacks on you and your family?
Yes.
And again, were you concerned that because you had already spoken to the police about Nuts' homicide, that people were considering you a snitch, that people thought you were a snitch?
I don't get what you're saying. Can you say that again?
Were you concerned that people already thought that you were a snitch when you did this interview?
What interview?
With the detective after you were shot at? After you were shot at with your girlfriend and your daughter?
No, my only concern was... No.
Do you recall telling the detective in this same February 20th interview, I left down, I came and talked down here. Everybody look at me like I'm a snitch now. It's just like I can't get no money. You know, I was just getting money just by doing nothing. It's just like, hey man, I need to borrow this right here, just hanging around, going to the mall. He paid for everything, but all of them, now they all come out here, they think I'm a snitch.
I always got my own money. When I need money, I knew how to go get it.
Would Thug give you money at times?
I'm not a handout type of person.
Would Thug give you money at times?
I never asked Thug for no money.
Would Thug give you money at times?
I can't recall if he gave me money, but I never asked him for no money.
When you said he paid for everything, who were you referencing?
The big money, the ballers.
Okay. Were you concerned that Young Thug had washed his hands of you?
Huh?
Were you concerned because you had been speaking to police that Thug had washed his hands of you?
No, I didn't need Thug.
All right. Do you recall telling the detective in the same interview on February 20th, 2015, he asked you, so basically Young Thug washed his hands of you? And your response, yeah, because I came and talked to the detectives and them folks in the street saying I'm a snitch, I'm a snitch, I'm a snitch. Nobody don't want to hang around me. I called my partners. They don't want to hang around me. It's like, what the hell? What the hell all this come from? What the hell is going on? Do you recall telling the police that?
The police so concerned about Thug, I was removing myself from him.
Do you recall at all talking to this detective about what happened that Monday night at Club Crucial with you and Kel, the fight between you and Kel?
I don't recall nothing specific that me and him talk about outside of the shooting with my child. And I barely remember some of this stuff. You talking about some years ago when I don't even know what I did 3-4 days ago. Like,
do you recall telling your girlfriend, again, when the two of you were alone in the room, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it? You recall having that conversation with your girlfriend?
you say it again?
Sure. Do you recall being alone in that same interview room with your girlfriend and you told her, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it?
On my child life, once again, on Izari life, I never seen no one face that was in that car shoot at me. At any time, if they got out the car, to this point, I never knew who shot at me. So when that detective was asking me, I just had to come up with something. I got no reason to lie about it. I didn't see nobody who shot at me. So y'all going back into interrogation when I'm telling you the truth. I don't know who shot at me. I have told them I didn't know. When they're gonna keep asking me, make me know, okay, cool. I'm gonna say, I'm done.
Do you recall being hesitant in the February 21st interview, and we're going to get to that interview with Detective Gaither, when she showed you a photographic lineup and you actually eventually pointed Tay out of a photographic lineup?
Because I know Gaither. I mean, I know Gaither. I know that, I mean, she one of them people that she got it out for me, so I didn't care. I was just trying to get it out. I get them out for me and trying to convince her. And trying to convince her is very hard to do. So I had to go through with it, even though in my heart, I knew that he didn't shoot at me, or he would have never shot at me. And to be more clear on it, before I went back to jail the last time, I was right around him. So I would never be with nobody that I believe shot at me while I had my child.
Why did you say Tay did it versus anyone else?
First thing came to my mind.
Why was Tay the first person that came to your mind versus anyone else?
Because in the midst of trying to convince the police so they could leave me alone, I just got shot at. Only thing was in my mind was, get back.
Okay, but you had to beef with Kel. Why not say it was Kel?
Because I had to convince them. I gotta make it seem. If I say Kel shot me, they're gonna, how you know? How Kel know where you stay at? So I gotta come up with something to make them know. Okay, well, Tay been over here. You know what I mean? So okay, Tay. I don't know. Like,
but
listen, you keep asking me. I told you I don't know who shot at me.
Why would Gaither have it out for you?
That would be speculation, sir.
I sustain the objection.
Well, you said she had it out for you. What makes you think she had it out for you?
I'll let him answer that question. It's posed.
You said she had it out for you. What makes you think she had it out for you?
Because she was trying her best to get me. She was trying to catch me.
Didn't she advise you to leave town? But you're right, it's a contradiction of what?
Not a contradiction.
Hold on. That comes from the interview. Where's that come from? Where's that statement come from?
His interview with her during the course
You
of
need to
it.
reference that. I'll rule the objection.
In your February 21st interview with her, did she ask you to leave town, go somewhere else, Cobb County, Clayton County? Did she tell you to lay low so that you wouldn't get killed?
No, she was saying it because she's saying that my name was, she just said my name kept coming up a lot.
Right, so she did not want you to be harmed. So why would she have it out for you?
I sustain the objection. You can rephrase.
During the course of that interview, was she encouraging you to lay low? Do you recall her doing that?
I think she was. I thought she was faking. So I don't know.
Outside of the interviews, would you talk to Gaither? Would you call Gaither on the phone?
No. The only time I talked to Gaither is when she called, but it was never about nothing in the streets or nothing.
Right, so
It was, hey, Miss Copeland, your name involved in the shooting. We want you downtown. This only time she called me, hey, Miss Copeland, they say you shot up this person's house. We need you downtown. I don't recall me and her having no conversations about nothing.
when you were locked up, would you have your girlfriend call Detective Gaither for you so you can speak with her?
You heard where I was, right? Where was I? In jail? You said, have I ever heard of 30 deep?
Yes.
Yeah.
And what's 30?
What you mean?
How have you heard of that term, 30?
How have I heard of the term 30 deep?
Yes.
Can you ask me in a way I can understand?
Sure. You said you've heard of 30D. You said you've heard of it, 30D.
I know about 30 deep.
Okay, what do you know about 30D?
But I can't stand when she say that. Sure. That is so disingenuous.
What you mean? What do I know about it?
Tell the jurors, you said you know about 30D. What do you know about 30D?
You hearsay the whole number of problems that question I can.
I'm over the objection.
Is 30D,
Objection to read it.
I stay in the objection.
I haven't asked the question.
All right, you can go ahead and rephrase, Nana.
What is 30D?
My neighborhood.
Is 30D a gang?
Huh?
Is 30D a gang?
Is it a gang?
Yes, sir.
And what you define as a gang?
How do you define a gang? Or do you, let me strike that. Is 30 Deep a group of individuals?
Meaning,
You said 30 Deep is your neighborhood.
yes, it's my neighborhood.
Okay. Is 30 Deep a group of people in your neighborhood?
No, it's just, I don't know.
Is it a group of people from your neighborhood?
I just know my neighborhood, I was growing up, I used to hear 30 deep a lot.
And when you heard of 30 Deep, what did you understand it to, what was your understanding of it?
It was cool.
And when you say it was cool, what do you mean?
Like, you know, I thought it was cool. I just see and heard people say 30 deep.
And when you saw and heard people say 30 Deep, were they talking about people together?
Oh, roll, sir.
Speculation.
I'll stand that.
When you heard people talk about 30 Deep, what was your understanding of what they were talking about?
I heard the rapper say, and his song 30 deep. I don't know. I heard Gucci Man rap about it. I heard like Jeezy rap about it. I don't know.
Have you ever been a member or an associate of 30D?
I don't know what associate mean.
Have you ever been around a group of people who identify themselves as 30D?
Have I ever been around a group of people that identify themselves at 30D?
Yes.
I know someone who I guess they say was 30D.
Did you ever consider yourself 30D?
No,
Okay. What about, did you ever consider yourself part of DRC?
no, I consider myself 372.
And what, is that why your Instagram was Woodity372?
My Instagram, Woody vs. Woody.
Back in 2014, did you have the Woody372 Instagram?
I told you I don't recall the Instagram. Back then they had several fake accounts with my name in it, but it wasn't mine.
You said you consider yourself 372. What was 372?
It ain't for you to know.
I'm gonna ask you again, Mr. Copeland, what was 372?
372.
Was that a game?
What do you define as a game?
Mr. Copeland, I'm asking a question.
I can't answer your question if I don't know what you're talking about.
Was it you and a group of people a part of 372?
And what's a group of people?
3 or more people.
But yeah, but it wasn't no. We didn't hang on it. Like we wasn't. I guess.
Do you remember in February of 2015 talking about 30D in an interview with Investigator Gazer and Investigator Dennis?
Huh?
Do you recall meeting with Investigator Dennis and Investigator? Do you remember meeting with Investigator Curry, in February of 2015 at Atlanta Police Department with your then girlfriend?
Was I handcuffed?
You were not.
Nah, I don't remember.
Do you recall having to go to the Atlanta Police Department after someone came to your home and shot at you?
Spaces.
You're gonna have to orient.
I'm gonna rule the objection as to form. If you got a better objection, Mr. Steele, you can pose it. Overruled.
Do you recall going to the Atlanta Police Department on February?
She's got to orient the witnesses to time and place, so I'm gonna overrule the objection, okay?
Do you recall having to go to the Atlanta Police Department in February of 2015 after you were the victim of an egg assault in which people tried to shoot at you?
I sustain the objection.
After somebody shot at you, your child, and your child's mother. Do you recall having to go to the Atlanta Police Department to be interviewed for that?
Yes.
What happened there? Okay. And do you recall speaking with a detective during that interview?
I don't know who I spoke with.
Okay. But do you remember, it doesn't matter, do you remember speaking with a detective about
Yes.
what happened with you? And during the course of that, interview, do you recall being asked about your affiliation with or your association with 30 Deep?
What you asking me?
Okay. Do you remember the detective asking you if you were a part of 30 Deep?
What I say?
You have to ask yes or no. Do you remember being asked that question?
No, I don't remember him asking me.
Okay. Do you remember saying that?
Basis. I need a form of the objection. Oral, sir. Again, if you pose another objection, I'll listen to it.
He asked you, he told you, you said to him, it's a whole gang.
I sustain the objection.
Let me ask you this. Let me just play it. Your Honor, the state will be playing the February 20th, 2015 interview, 156-28 through 156-44.
Oral, sir. You said hearsay, I've overruled it. All right, thank you. It's impeachment. Is that correct, madam?
Yes, Your Honor.
All right. Sure.
There's no exhibit number, nothing for the record.
I'm going to mark
Let
it,
me
Your
fix.
Honor.
Let me fix that. Yes, you do need to mark it as for identification, madam.
Yes, Your Honor. The state would like to send a 378 Yankee Charlie, and it'll be from 156-28 to 156-44.
That 378 Yankee Charlie.
Yes, Your Honor. 378 Yankee Charlie.
And any objection to states 378 Yankee Charlie from 15-620 to 15-644?
Just one clarification. What is the state reports this name?
I can't hear you.
I'm asking what the state reports this exhibit to be.
This is the February 20th, 2015 interview of Mr. Copeland.
Okay, thank you.
You're welcome.
Now, I'll object also to hearsay. I heard the state say this would be investigated.
You're right, I have to give context to the entire statement.
I'll overrule the objection. It's admitted, and maybe that particular section is admitted from (15-628) to 15-644.
Huh? My cousin was. What were you associated with? And then everything else that done rolled about with it, it's starting to come back to harm.
And Your Honor, I'm going to go back, 'cause I think it's maybe 156-27.
were 30 deep.
Okay.
Huh?
My cousin was.
Were you associated with? And then everything else that done rolled about with it is starting to come back to harm.
And we're ending at 156:45. I'm gonna also show you, you know what, strike that. To your knowledge, was Demekion Garlington part of 30 deep?
No,
To your knowledge, was Shannon part of 30 deep?
no,
Did you ever claim affiliation with the Bloods?
who, me?
Yes, you.
Yeah,
Okay. What blood set?
Bloods, period.
When you say Bloods, period, what do you mean?
Blood. I call myself a blood.
Did you ever leave or stop calling yourself a Blood?
You say, did I start calling myself a blood?
Yes.
Yeah,
When was that?
2015.
Okay. And
I think 2015.
And do you have tattoos that would be considered representative of being a member of the Bloods?
No,
Do you have a 5-point star tattoo?
it don't have nothing to do with bloods, though.
Okay. Do you have a 5-point star tattoo?
Yeah.
How many of them do you have?
A lot.
When you say a lot, can you put that in numbers?
More than 5.
And with your 5-point stars, are they colored? Do they have a color?
Yeah.
What color is that?
What you mean? What color are they?
Yeah, what color are your 5-point stars?
Some on just plain, some red, some green.
Do you know how many red ones you have?
No,
Okay. Do you know how many green ones you have?
no,
Do you know how many that are not colored at all?
no.
Was Demekion part of the Bloods?
You gotta ask him that.
Okay, I'm asking you,
Not to my knowledge.
right? Do you
Well, I don't know. I can't say not to my knowledge. I don't know where he was.
Okay, I know some of you may have to go, but I'm going to show this last one that shows about 15 moments that's crazy in this trial. And it's not long. It's not as long as that video, but I just want to show it. I thank y'all for being here with me. I really appreciate it. Keeps my mind right.
You just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. You can take a break.
The thing is that, Your Honor, we did not,
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
If you have other evidence independent of this, I'll consider it at the appropriate time.
and we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the state, 306 Georgia at 35, Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop. I was speaking.
Ms. Love, y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer, he invoked his right to not speak anymore, and I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have no. I need to make a record. Your Honor,
Mr. Steele, wait a second. When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong.
I remember y'all trying to assassinate me right now in 2024. That's what I remember. That's what I remember. All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on. Your Honor, am I on trial, Your Honor?
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you're not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too.
We are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out.
So related number 3 is I'm going to start, if appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors. And just we'll take whatever and we'll come back the next day. So that's 3. Number 4 is I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I'd like to have it. I'd like to watch the Super Bowl without having to come back to try your case. I hope that your case is resolved by that time, whatever may happen. But I think that we can do a better job at presenting the evidence and streamlining whatever for the fact finder to be able to make a decision. So we're going to start gathering on Saturday and Sunday. And the last remedy, and I don't say this being otherwise mean and contrary and everything else, but I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have. I do have some concerns about 120 days of trial time. That's going to take almost 4 months. And, I'll remind the state, you told me, or Ms. Hilton told me, it's going to take about 6 months. At this rate, it's going to be 12 months, and that doesn't include anything that the defense may choose to. I'm concerned about your case, Chief, at this point in time. The defense will present whatever they wish to do with, and I'll deal with it. We'll deal with it accordingly. But
we were trying to be finished by June, frankly, as I told the court earlier.
Yes.
We can't control cross-examination, and that has extended our estimation of the time that we expect.
Well, like I said, if you disclose things, if you don't disclose everything, and we don't disclose things timely, then what I'm doing is I'm taking up more time. What I want to do is I don't want us to take up 2-3 hours. I can't do that anymore. So I'm telling you, you need to make very sure that you've disclosed the evidence and you'll be able to tell me what day you did, because if you can't, I'm gonna exclude it. That's my remedy at this point in time. That's my first remedy I'm gonna turn to, because I don't want to initially do that, but I've kind of gotten to the point right now where it's kind of like, I don't think that a lot of things I do are for abuse of discretion. I don't believe that, given what I have indicated to all of you as a group, is not a valid assertion at this point in time. It's just taking way too long. So you all can help me out help yourselves out by identifying issues, and then if we gotta kind of just take them out of turn, and I gotta take a day and deal with them, that's fine. But I need to make sure that everybody's kind of on the same sheet of music, that we're not kind of just stopping things. Oh, I wasn't given that. Or like I indicated earlier, we just found something on Instagram last night. Well,
then it should have been turned over within the hour that you found it. With a we need to talk to the court in the morning about it first thing. So a lot of times, so we can be kind of forearmed and take care of it. So that's what I kind of want everybody to kind of work on. I'm not interested necessarily in taking up your weekend. I really am not. And I'm not interested in holding any of you in court, but those are tools. They're tools. And I mean, we are more than a year's worth of into this, and we are 40 witnesses deep. So I'm just telling you all, just think about and kind of just in conjunction with what I told you all earlier today, and then we'll talk about the witness list tomorrow, and we'll see what we can kind of get proceed better with. All right.
This sounds like the truth. You're the driver. You really cleared something up for me, the thug. And I got to go out here and find a picture of this joker, because it's important. Because I don't think he should get away with it if he was in the car. You're not making this up. Thug was in the car.
Yeah.
All right. Okay. Let me.
Now I can't testify. I can't do none of that now.
All right, you ain't got to testify. That's on you.
Put me on blast front.
Well, that's not what I do. What I do is I'm trying to go slow and get all the information I need in relation to you, right? That's all I'm talking about. But the other people involved, I mean, it sounds to me like Thug got you all involved. I mean, I know you're a grown man and everything, but he came down here with an easy way to make money, it sounds like, and it went. Who knew the police were going to be there?
Yeah.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, sir.
call in our jury. It has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
Do what I need a lawyer for?
Right.
What?
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he had.
He talking about Uniform Superior Court rules like he really saying something. You have to file a notice of appearance as well if this was going to be his attorney. She was just standing in for that morning. Supposedly he was going to call him in at 8:30 before the jury came, and he was going to say he took the fifth and go back to jail. But that didn't happen like that. The ex parte took place for 2 hours that morning. This is so crazy. And Regina, she had several little back and forths with Hilton and Love because they didn't do nothing right. But it's going to all come out in the wash. And it's going to be before an appeal.
Has 10 days to object.
Just for the record, I'm his counsel.
Say again.
I was never his counsel. Attorney Melvin was his counsel, and I was stepping in as a courtesy for judicial efficiency. I'll motion to withdraw.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
Okay, I'll get that done now, Judge.
Okay, all right.
You got 5 minutes. Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was, don't take my notes. No.
In no way, but I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all are going to see each other over and over and over again. And, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right? So I'm just going to recess and we'll see where Mr. Melnick is at that point in time. And then I can talk about Monday for certain. Okay? All right. Okay. I'm just going to recess in place. All right. Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me maybe, You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an
may be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not
Sure,
I
don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want till 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele. That is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got
Because
Well,
unless
I
you're
got-
sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled
let,
to the-
that leads to be told. But
But
State, do you have
right
anything
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
because
paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love. Sir,
Is not.
that's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you've made your, no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I ask for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. Objection.
Yesterday, did you tell myself and my colleagues, Ms. Love and others, about Little D and Shannon being in your vehicle the night of the murder?
Huh?
Yesterday, did you tell myself, Ms. Love, and a few of my other colleagues that Little D and Shannon were in the car with you the night of the murder of Diamond Thomas?
I told you and them that what I told investigators in June, when Nut got killed, something different, because I was trying to finesse my way out of a situation. So I said, I picked up D and Shannon. D never told me nothing. I made it up to clear myself up. And that's it.
And was that yesterday that you said that? Did you tell us that yesterday, what you just said?
You asked me to be truthful. And I didn't, and I told you. What I told the investigator back then wasn't me being truthful. So I'm telling you something that I didn't tell them because I ain't trying to go back to jail.
I got it. But I asked you was yesterday, the first time you said this part, and now what you're saying today is what is truthful. What you're saying right now, what you're trying to tell the jury right now, is what you are now saying is truthful.
What I'm trying to tell you is our conversation was about something that I said in the past.
I understand. I'm asking
I
you.
asked that Mr. Copeland allowed to finish his.
Okay, all right.
Oh, I thought he wasn't.
Mr. Copeland, you need to finish your answers?
No, I need a break, Your Honor.
Say again?
I need a break.
You need to use the restroom?
No, I need a break. Like, I need a break.
Sir, it's not time for us to take a break at this point
Well,
in time.
okay.
Okay? I mean, unless you need to go to the bathroom or some other reason, we're not gonna break at this point in time.
Do you need a few moments?
Just know I started embracing DB, Lil D after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced Little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when our three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What?
Objection, Your Honor, family approach. Sure.
We'll be in recess 10 minutes.
I'm gonna take the field.
Now, did y'all hear him say he was about to take the fifth? When they brought that to the court's attention, he'd swear he don't know nothing about that and that didn't happen. I'm so glad that you guys stayed with me this long and looked at the videos. Bae, you need to go back. If you haven't seen the entire video, go back and listen to the reading on the law of immunity. You will be shocked. Well, you won't be shocked, but you will really get probably a laugh out of these people have done nothing right. That immunity means nothing. They're actually really just strong-arming people into doing what they want them to do. And the new YSL trial tried to start the other day, but a lot of those guys have never met their attorneys. Some of them don't have attorneys, and they've been locked up all this time. Some of them, what they were offering them was life plus X amount of days as a plea deal. None of them took the plea. This is really horrible. And everybody pretend they're so concerned for Woody, but in their commentary, they say a lot of dangerous stuff. They all keep calling him a snitch. And as if that's really true, then what do y'all want, something to happen to him or something? That's crazy. I mean, I don't understand people. And all this street code. You don't have no code. If you don't have a code of ethics and a code of conduct and a code of self-discipline, all them other codes can go out the window because they mean nothing. And on that note, since you guys have been here so long, I'm going to get ready to go so you all can start your week. And I'm going to try to rest up and continue researching. I will read the rest of that immunity because it was 19 pages and I think I read about 10 or 11 pages. But it was very, very interesting what it had to say. Very interesting. And it's about the statute and as it relates to the federal statute. You see, they took the RICO state charges from the federal RICO charges. And we do know RICO was enacted for mafia, the mob. But unfortunately in Georgia, they're using it for school teachers and for what they call gangbangers. And as Big Jeff, which is Young Thug's father, as he would say, Georgia is not a gang state. He said you can get on the internet, you can look in any phone book, You can look anywhere and you won't find a gang attorney in Georgia. Gang states, what are gang states? California, that's where Fonnie is from. Right out of the heart of the Piru Bloods. Inglewood. The Gaither, the no good detective. Where is she from? Chicago. Gangster Disciples. She say was all around her, but she wasn't one. The lying detective Dennis. Where is he from? St. Louis, Missouri. Where the gang members, Crips and Bloods. So these people are using people to pretend they're gang experts with no paperwork, but yet they can go back and get all of these, and I don't know, maybe they didn't have to turn any of these things over to them, but with all of these interviews, they had no paperwork, but yet they can play, and everything they're doing is off the internet, by the way, or what somebody said. They're taking hearsay on top of hearsay on top of hearsay. So they're talking about three-say. I've just never heard of nothing like this in my life. And they are the laughing stock of America. It is good to see cameras in the courtroom, which they've been in there on court TV and places like that all the time. But it is good that we are witnessing this railroad. Although we're not taking it serious, not most people on YouTube, they just making money. And I can't knock anybody for doing what they do because these are part-time jobs. And for some people, it's their full-time job. But it is a very, very sad day when we as a people who complain about everything that happens to us. And it is a lot that happens to us. And we don't try to educate as well as entertain. And we have lawyers, people that actually have license, and a lot of them are in different states, but they don't even listen or look at a video to talk intelligently about it. They do a lot of speculating and what shoulda, woulda, coulda happened and don't even know what's going on. But I did do a video on Brian Steele and his wife. It's an excellent video. It's just a little video I did. I did one on the judge who's supposed to get the papers now because the Supreme Court struck down Attorney Weinstein's emergency mandamus motion when he asked that they take a look at this case because they have a witness on the stand and it's really going crazy. And the reason they turned it down, they explained to him what he needed to do to perfect it. And so he did do that. He has filed with the appeals court because the judge wouldn't certify it so that he could follow the protocol. So he had to go that route. But this lady who may get it, he said that she may not get it because whoever gets it is not supposed to be on the same level as Judge Glanville because he is the Chief Justice. And he's the Chief Justice not because of his intellect or because of his service to the country. It's because they do that on a rotational basis. And it's just his turn. And he's not doing a good job of it. They do these type of things, put us in positions we don't know what we're doing. These people act like they don't even know the law in Georgia or how to apply it. And they do that just to show the world and ourselves, see, y'all can't do this. So we're going to make sure y'all don't get here the next time. And they don't have people opposing them before now, but you can guarantee they're going to have people opposing them. And then everybody is so stuck on Trump and on Biden. And I'm trying to tell people that that's the same bird. You need to be stuck on intelligence and learning some stuff. We don't know politics. We know emotions. And emotions does not work in business. Unless, of course, you're in the funeral business. And even then, you can't cry as hard as the family. So we've got to start educating ourselves, if for no other reason but for our babies, because, you know, they are our future. Regina said, I was wondering when he was going to plead the fifth again. The last time he said it, the judge put him in jail. Yeah, and the judge pretended he didn't hear that, and they pretended they didn't hear it. You know, they don't want that. But in our rights, from what we just learned, that's what his lawyer told him to do, and that's what he did. It wasn't until they knew his lawyer wasn't there that they pulled all of this trickery. All of that, in my opinion, was by design. They'll never make me believe different. Love make Fonnie almost look like a decent human being. And both of them ran for DA the year that they originally ran in 2020. She didn't get it. Love didn't get it. She was a juvenile justice judge. And that judge that I talked about, Belinda Edwards, she was a juvenile justice judge. She was so bad and did things so wrong, they promoted her up to the Superior Court. So they start out with our young sons. And the pipeline to prison is real, whether we want to believe it or not. And now they're doing it to our daughters. We got to be careful. They're doing it to us, seniors. We got to be careful. And we got to start teaching something before we leave here. That's all I have to add to the story. But again, I'll bring another story to you on Wednesday. I appreciate everybody for being here. Have a beautiful beginning of your week. I'll try to do likewise. This is the 4th of July holiday week. So, be careful. People will be shooting off firearms and fireworks. So be careful. And I hope the same for myself. Everybody who came in later, hit the like button if you forgot to hit it. If you're not subscribed, consider subscribing to the channel and consider joining my membership. It really helps. I thank you very much. Share the video. A lot of people don't get to hear the knowledge that I try to share. But I'm going to keep it up because one day they're going to want to know, what did that woman say? What's her name? I think it's Toothless. What was she talking about? Because I'm going to try to always give you something that you can take away and you can research for yourself. And then you can know it in your knower. And you don't have to say what Toothless said. You can say what you know because you researched it for yourself. And on that note, I'm leaving the tiger's den. Goodbye. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.